Or refusing ex parte entry measure under Section 9 of the Act, if Section 9 application is filed before the court exercising jurisdiction under the Act of 1996. Though appeal under Section 37 of the Act of 1996 maintainable against an order refusing ex parte measure, the scope of interference in such appeal is limited, as the appellate court is only required to consider whether consideration of prayer of ex parte interim measure can be deferred till the appearance of the respondent. In an appeal under Section 37 of the Act of 1996 against an order granting ex parte measure, the appeal may be entertained only in exceptional cases, as the aggrieved party will have an efficacious remedy of moving the same court which passed the order to vacate the ex parte order. Law laid down in Symphony Services Corporation Private Limited stands overruled. Interim measure granted by this court stands extended till appearance before the.
I'm grateful.
My lords, on submission, my lords. As I have filed a memo for 4 fresh matters which has to be connected to a petition which is to be listed on 1/8, my lords. It shall be allowed, my lords. Requesting. Oh, just now I gave to court house.
It's been given.
Yes, thank you, my lords.
Serial number 3. Skyly have it in the next week.
Bad case. Compulsory retirement.
Page 2, 7 to 12. Page 3, 13 to 15. Page 4, 16 and 17. Page 5, 18 to 20. Page 6, 21 to 26.
My lord, serial number 22, my lord. Serial number 22. We will have to
Yes.
file some typed copies, translated typed copies, a short accommodation may be given.
Yes. At the request of the learned counsel for the petitioner, list after 2 weeks.
Obligement.
Page 7, 27 to 34.
Serial number 27, my lord. I have it on next week.
State. Yes.
Page 8 to the 35. This one, very, number 2, 30 state.
Lord, matter pertaining to my lord, disciplinary proceedings against the sub-registrar,
The
Not-
finding of the tribunal is that it is not the same complaint.
same charge,
It is not the same charge as the
is
finding.
not the same charge.
There are 1008 deeds
Lord,
registered by you in violation is the finding.
yes, Lord, my submission is, my lord, the crux of the matter is, my lord, I have violated the circular.
What is a circular?
Circular is that, my lord, I have to take, I cannot take, my lord, handwritten khata, while manual khata. I should take form number 9 and 11B while registering the deed.
When was the circular issued?
Lord, 9/4/2009.
6/4/2000.
I am sorry, my lord, 6/4/2009. Lord, the 6/4/2009 was challenged before this honorable court. Lord, this honorable court in a public interest litigation in G. Ramachar versus state quashed the circular on the ground that, my lord, state government has no jurisdiction to issue circular, my lord, restraining the sub-registrar from registering the deed. Lord, the state being aggrieved by the order of this honorable court has filed, my lord, SLP, and there is an interim order of stay. There is an interim order of stay. Lord, considering these aspects, in the earlier inquiry, Lord, I have faced the inquiry, retired.
Yes, 6/4/2020, 24/1/2013, 23/4/2014.
Yes, ma'am.
During tenure, so and so is also mentioned.
Lord, these circulars, Lord,
What is the finding of this court in the judgment which you are referring to?
G. Ramachar, my lord. Lord, the G. Ramachar's judgment is, my lord, available at page 255, annexure R4. The Lord, relying upon Lord Basant Mehta versus State of Rajasthan, Lord, the division bench of this honorable court says that Lord, the a document which is opposed to public policy, Lord, can be restrained from registering the document.
Hmm.
But sub-registrar is Lord, governed under the Registration Act and rules. Therefore, all circulars issued dated 6/4/2009 and all further circulars are quashed.
Registration. What is 22 capital A?
Lord, documents opposed to, my lord, public policy. Your lordship may kindly take, my lord, section 22A of the Registration Act.
2020 circular is not yet quashed.
Please, 2020 circular is not quashed. Lord, the order, it's the order dated 18 March 2016 is the judgment rendered by this honorable court.
Let me go. Yes. Where is the helmet?
It appears that it is because the earlier circular,
Please.
2009 circular, was issued under section 22A,
Yes, ma'am.
which stood
He
struck down.
struck down in Basant, my lord, Basant Nahata versus, my lord, State of Rajasthan,
Which is in 2005.
2005-6 SCC, my lord.
Thereafter, it appears in 2013, 14 and 20, certain further circulars have been issued. What are those circulars and on what strength have those circulars been issued?
Lord,
If
those
it's
circular,
under 22A,
those, again, my lord, under section 22A.
which are those circulars?
Lord, the circulars, Lord,
State government may, by notification in the official gazette, declare that the registration of any document or class of documents is opposed to public policy.
public policy is section 22A.
Registering authority shall refuse to register any document to which a notification issued under subsection 1 is applicable.
Lord, the question, Lord, in the inquiry again revolves around Lord, I was working as sub-registrar at Madanayakanhalli, my lord, from 1/4/2014 to 16. I'm sorry, my lord. The articles of charge in the earlier occasion is, my lord, may I request my lords to kindly take, my lord, page 85. Is the first circular. One, the allegation is pertaining to, Lord, acceptance of manual khata, and I have registered the deed, violating 6/4/2009 and 24/1/2013, 23/4/2014. Those circulars are quashed by this honorable court, my lord. However, Lord, there is an interim order of stay. Lord, I have faced the inquiry. Retired district judge. My lord, retired district judge was appointed as inquiry officer. Lord, charges are held to be not proved. I have been exonerated. Then, my lord,
On what, on the ground that the circulars are not.
yes, my lord, on the ground that circular cannot bind the sub-registrar, and, my lord, there is a judgment of, my lord, the inquiry officer relies upon the judgment of this honorable court in respect of, my lord, the very applicant, very petitioner in, my lord, Devraj versus State. Lord, this honorable court has held that the circular issued cannot bind, my lord, my lord will find that order at page 162. Your lordship will find the petitioner's name in respect of the very petitioner. Page 162, my lord. Your lordship will find Devraju B versus State by Madanayakanhalli. Lord, in respect of the very same incident, this honorable court says that, my lord, para 5.
Yes.
The learned counsel for the petitioner by way of reply would point out that the question is no more res integra, since the circulars could be an page 63, my lord. 163, I'm sorry, my lord. Para 5.
Hmm.
When the petitioners are duty bound to register the document, they have been quashed by a division bench of this court in so and so connected matters following the division bench decision in S. Srinivas Rao versus so and so, and yet another decision in Sulochanamma versus so and so, where it was held that when a document is presented for registration fulfilling all the requirements, the sub-registrar has no option but to register the document unless the document is not in conformity with the provisions of Registration Act 1908 and relevant rules, and sub-registrar was entrusted with the duty of registering the documents in accordance with the provisions of Act, and he was not authorized to go into the genuineness or otherwise of the documents presented before him. If the documents are bogus and false, the party affected by it will have the right to initiate both civil and criminal proceedings to prosecute the party who tries to have the benefit from such document, and also to safeguard his right, title, interest. It was not for either Tahsildar or sub-registrar to express opinion as to the genuineness or otherwise of the documents unless called upon by the court of law or any other authorized investigating agency. Reference was also made, drawn to a judgment of the Supreme Court wherein 22A, section 22A, as inserted by the legislature of Rajasthan, made by the act which is per parameteria with the law prevailing in Karnataka, and that the circulars, if any issued overriding the provisions of the act and rules, would not have any precedence, and that there was no irregularity in the sub-registrar not having complied with the circular contrary to the provisions of law. My lord, this is again, my lord, pertaining to the very same issue which is covered under the articles of charge. Madnaik, very not allegation is pertaining to Madnaiknalli sub-registrar office.
And one of the allegations is you have
Yes.
registered a document which is not within the territorial jurisdiction of the sub-registrar.
My lord,
It is a new allegation.
that is the allegation, my lord, in the previous inquiry, not the present inquiry. Not the present inquiry, my lord. Lord, that apart, my lord, this is the third inquiry, my lord. First inquiry, my lord, by my employer, I have been exonerated. Second inquiry, my lord, which is challenged before my lords. Third inquiry by another person, which is closed by the very same my lord authority, that is Uplok Ayukta, on the ground that, my lord, previous inquiry by the employer is conducted, file is closed. And, my lord, one additional factor is there are two delinquents in the inquiry. But it would be a futile exercise for this reason. One has, my lord, faced the inquiry, has been exonerated. But again, my lord, I have to face.
That again on the ground that the circular is
Lord, it is the on merits, my lord.
not on the circular.
No, ma'am. It is the inquiry conducted by the Lokayukta itself. But a recommendation is made to exonerate on the ground that charges are not proved. It is a joint inquiry.
And
But-
against that, there is
Please,
nothing, against that, nothing further has happened.
my lord, I am told that, my lord, I am not sure. My lord, petitioner has, the state government has accepted and exonerated the co-delinquent. Lord, his name is Hanumantappa.
Yes.
The finding of the tribunal, para 7 and 8. But it very clearly shows not that this is not subject matter of earlier inquiry. Para 7 and 8 at ink page 49, 50 and 51. But insofar as the judgment of the Honorable Single Judge of this Honorable Court is concerned, not that is from the perspective of section 482 petition. For the purpose of quashing criminal proceedings, my lord, his lordship felt not that it does not qualify as a case for investigation. So, my lord, that judgment has been, and also that judgment relies upon my lord Ramachar judgment, which is subject matter of interim order by the Honorable Apex Court. But and also the additional ground factor which my learned friend canvassed about the co-delinquent. The co-delinquent, my lord, he has been exonerated on the facts, my lord, on the merits of the case, not on the question whether he was empowered, not empowered, jurisdiction, no jurisdiction. But in the facts and circumstances of the case, the findings of the inquiry officer is the charges are not proved. And this is only at the stage of entrustment that my learned friend has approached here, without not raising any of the legal grounds about natural justice, jurisdiction, or not non-following the principles of natural justice. That's all.
As a matter of fact, if the very aspect with regard to the initiation of the inquiry, the contention is that it is in he has accepted and registered documents in violation of the circulars.
Yes,
If that is found
yes,
in his favor,
yes.
then what would be the purpose in continuing the inquiry?
Not, that's not in his favor insofar as the trauma charge judgment is concerned. If not, the trauma charge judgment does not hold field after not what the Honorable Apex Court does with the case, then not, it is a different situation altogether.
Yes.
But the very fact that the co-delinquent has gone through the process of the inquiry and has been exonerated on merits, not the apprehension of my learned friend is misplaced. That there will be any different kind of finding or not, that there will be victimization or any.
Which is the order of the, insofar as the co-delinquent is
Lord,
concerned?
I have produced a
Along with the
memo.
memo he has placed.
Lord, memo is filed on 10/6/2024. Lord, inquiry report is in English, my Lord. It is on merits. Finding starts from page 8. Para 30, 31, 32. And my Lord, relying upon rule 73 of the my Lord, registration rules, the inquiry officer holds that sub-registrar cannot refuse registration of document unless an executant of the document my Lord, opposes registration. Once document is admitted, sub-registrar cannot refuse registration, and registration will not confer any title as such.
But the software is developed in such a way, unless you produce the authentic documents,
It won't
the
not.
window will not open.
No, it is, my Lord, it is introduced, my Lord, from 1/4/2023.
Even earlier to that.
My Lord, Kaveri software is developed, my Lord, and it is introduced with effect from 1/1 my Lord. Before that, my Lord, it was Kaveri software was not available.
Even earlier, it insisted for authentic documents from the, issued by the Gram Panchayat, online documents. Only if those documents are annexed, the window would open.
Those circulars are quashed, my Lord.
But may I suggest this, Lord, if it is not, my learned friend would also agree. We'll complete the inquiry in 3 months, Lord. Since the inquiry is already completed in relation to co-delinquent, we'll complete in 3 months or
But
2 months, your lordship may suggest.
Again, my Lord,
Subject to cooperation by the DGO.
this is the third inquiry, my Lord. I am made to face the third inquiry in respect of Lord, very same incident where Lord, FIR is quashed. The charge memo I have faced, my Lord. It is not that, my Lord, I have challenged the first inquiry. I did not challenge it.
Is also on the basis of some, this is factual as regards the co-delinquent is concerned. Is also aware of this.
Relevant data is fed in the computer system.
But your lordship may kindly come to, my Lord. Lord, the page, this is the third complaint, my Lord. kindly come to my lord page annexure F, page 303 in the writ petition. But the second respondent Lokayukta, my lord, closes the complaint not on the ground that, my lord, he has initiated inquiry, on the ground that employer has initiated inquiry, retired district judge has submitted a report that charges are not proved. Therefore, there is no question of page 310, para 73. 310. Again, my lord, in the present case, page 310, I have appeared and I have, my lord, annexed those orders. The above said inquiry report shows that CR Javid Pasha, retired district and session judge, was appointed as inquiry officer, and he has conducted the departmental inquiry against the respondent number 1 and 2 others. So and so. It is held that none of the charges framed against the respondent number 1 are proved, and even the charges against so and so are not proved, and all of them have been exonerated. As stated above, District Registrar Ajaynagar has also reported that inquiry report has been accepted. Government order is passed accordingly. Hence, it has to be said that in respect of allegations made in the complaint, already departmental inquiry has been conducted against the respondent 1 and 2 others stated above, and all of them have been exonerated. Hence, there is no purpose in proceeding further in respect of this complaint, as the departmental inquiry has already been held as stated above regarding the allegations made in the complaint. Hence, for the reasons further investigation of this complaint is not necessary, this complaint may be closed. But on 28/12/2020, Honorable Lokayukta, my lord, closes the complaint.
You said in the first inquiry, there is an allegation that he has registered a document which is outside the territorial jurisdiction of
Yes.
his office. But the tribunal gives a different finding.
But
Tribunal
tribunal-
says, this is the subject matter of inquiry now. The allegation is that you have
But,
registered a document.
What
Wait.
is the present charge memo?
Yes, present charge memo is at, my lord, page annexure A18.
Page.
My lord, how it starts, my lord, is may have some relevance. Annexure A15, my lord, page 189. How the present inquiry is initiated, because, my lord, one Shri Jairamaya gives a complaint. Page 189 is the complaint. Basis for holding inquiry is page 189.
What is the charge?
Yes, ma'am. Charge is not page 197, order of entrustment, my lord. Page 197.
Yes.
In the impugned order of entrustment, Lord, it does not say that, my lord, I have registered, which is outside the scope of Lord Sub-registrar's office. Complaint is, my lord, that I have accepted form number 9 and 11 contrary to the circular and registered the deed.
Receiving manual form number 9.
May I read, my lord? The But page 199 is the reason for entrustment. My lord, may I read? Lord, I will try to translate it also. Page 199, my lord.
Please.
Lord, police till my lord, page 199 is the discussion, my lord. ಪೊಲೀಸ್ ಉಪಾಧೀಕ್ಷಕರು ಇವರು ದೂರಿನ ಆರೋಪಗಳ ಬಗ್ಗೆ ತನಿಖೆ ನಡೆಸಿರುತ್ತಾರೆ. ವಿಚಾರಣೆಯ ಕಾಲದಲ್ಲಿ ಪಡೆಯಲಾದ ದಾಖಲಾತಿಗಳು ಮತ್ತು ಮಾಹಿತಿಯನ್ವಯ ನೋಂದಣಿ ಮಹಾಪರಿವೀಕ್ಷಕರ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳ ಡಿಜಿಟಲ್ ಸಹಿ ಇರುವ ನಮೂನೆ 9, 11A, 11B ಪರಿಗಣಿಸಿ ನೋಂದಣಿ ಮಾಡುವಂತೆ ಸುತ್ತೋಲೆ ಹೊರಡಿಸಿದರೂ ಸಹ ಅದನ್ನು ಪರಿಗಣಿಸದೆ ಕೈಬರಹ ಫಾರ್ಮ್ ನಮೂನೆ 9 ಮತ್ತು 11 ಪಡೆದು ನೋಂದಣಿ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. The Deputy Superintendent of Police has investigated the matter. During the investigation, it is found that the Deputy Inspector General of Registration has issued a circular which stipulates that Sub-registrar is required to obtain form number 9, 11A, 11B for registration, and which prohibits acceptance of handwritten form number 9, 11A. ಈ ಸಂಬಂಧ ನೋಂದಣಿ ಮಹಾಪರಿವೀಕ್ಷಕರು ಮತ್ತು ಮುದ್ರಾಂಕ ಆಯುಕ್ತರವರಿಂದ ದಿನಾಂಕ 24/7/2015 ಸ್ಪಷ್ಟೀಕರಣ ಪಡೆಯಲಾಗಿದ್ದು, ಸರ್ಕಾರದಿಂದ ಹೊರಡಿಸಿರುವ ಸುತ್ತೋಲೆಗಳಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಸ್ವತ್ತುಗಳನ್ನು ನೋಂದಣಿ ಮಾಡಬೇಕೆಂದು, ಇಲ್ಲದಿದ್ದರೆ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಗಳನ್ನ ಉಲ್ಲಂಘಿಸಿ ನೋಂದಣಿ ಮಾಡಿದಂತಾಗುತ್ತದೆ ಎಂಬುದಾಗಿ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಿರುತ್ತಾರೆ. In this regard, the Inspector General has issued a direction on 24/7/2015 that Sub-registrar shall follow the rules as stipulated in the circular dated 24/7/2015, failing which it will be treated as violation of circular. ಈ ರೀತಿ ಸ್ಪಷ್ಟ ಮಾಹಿತಿ ಹೊಂದಿರುವ ಸುತ್ತೋಲೆಗಳನ್ನು ನೀಡಿದ್ದರೂ ಸಹ ಅದನ್ನು ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಮಾದನಾಯಕನಹಳ್ಳಿ ಉಪನೋಂದಣಾಧಿಕಾರಿ ಕಚೇರಿಯಲ್ಲಿ ಉಪನೋಂದಣಾಧಿಕಾರಿಗಳಾಗಿದ್ದ 3ನೇ ಎದುರುದಾರರು 3/2/2014 ಜುಲೈ 2014 ಕೈಬರಹ ನಮೂನೆ 9 ಮತ್ತು 11 ಒಟ್ಟು 1108 ಆಸ್ತಿಗಳನ್ನ ನೋಂದಣಿ ಮಾಡಿರುವುದು ವಿಚಾರಣೆ ಕಾಲದಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. On investigation, it is found that the delinquent number 3 has violated the circular from 3/2/2014 to July 2014, accepted handwritten 9 and 11 and registered 1108 documents, thereby committed misconduct.
Circulars for question 2015,
2016, my lord.
16.
Lord, 2016. Lord, the present old inquiry. Lord, the finding that it is not covered may not be correct. Kindly come to, Lord, the impugned order as well as the earlier inquiry. Earlier inquiry, my lord, page 86. Lord, the period is from, my lord, 1/4/2014 to 16/7/2014. Lord, the present inquiry is from 3/2/2014. It is for a lesser period. That is for a, my lord, larger. Lord, I am made to face the third inquiry, and my lord, because of this, Lord, I am denied promotion. Lord, I am.
Let us await the decision in Ramacharya. We'll have to await the decision of the apex court. Let things stay as it is, because as a matter of fact, on almost the identical charges he's faced inquiry. And on this ground, probably if you succeed in the Supreme Court, even that will have to be revisited. Yes, admit. Learned, government advocate takes notice
My lord, the,
or
my lord, notice is,
already, yes.
For granting, confirming the interim order granted. And if it is not a type of place, would I suggest not to feel to the article structure, complete the inquiry and keep them not reporting the state or basic.
He has to face that inquiry.
Yes.
He says that on the very same charges he's already faced. And on this, the applicability of the circular, it has been found against.
Yes.
Very same thing.
But my-
Therefore, we'll have to wait.
Yes, yes.
I'll record that.
So, he may also be exonerated. In that case, not, we may not have to wait unless we not complete. It is all that I. Only
No,
to.
exonerate, the difficulty is this. No, we understand your contention. The exoneration will have to be, now dehors the circulars.
Yes.
If ultimately you go into all other aspects except the circulars, then probably he'll be exonerated. Ultimately, if it is found that the circulars are, as a matter of fact, enforceable, then the entire thing is derailed. We don't want
not,
that also to happen. It is either way, it will depend on the decision of the apex.
but your lordship may quash the present impugned order, so which shall be subject to result of, my lord, if,
We'll keep it in abeyance.
please, my
We will keep it in abeyance.
lord,
The further proceedings will keep in abeyance.
there is an, my lord,
Yes, that will
there
extend.
is an
But
interim,
to say that
but,
shall be.
may I
quashed on
suggest
that-
this, my lord, your lordship may quash the impugned order, which shall be subject to result of, my lord, SLP numbers, my lord, otherwise, my lord, I will be deprived of, my lord, promotion. Lord, for the last,
For, when you're saying that there is such a proceeding, will you contend that this is initiation? It cannot be. Therefore, it is not initiation.
But I will be bound by the order passed in SLP. Your lordship may,
Heard both sides. In view of the fact that the judgment of the co-equal bench of this court in 2016,
but,
Ramachar,
page 255, writ petition 18939 of 2009, dated 18th March 2016.
judgment of the co-equal bench of this court in writ petition number 18939 of 2009 and connected cases is pending before the apex court
SLP number
in,
Page 292. Itself.
in one
292, my lord.
in SLA number 15837 and 15838 of 2016 with an order of stay of the same. We are of the opinion that the interim order granted in this case is liable to continue. The interim stay shall remain in force. The parties are free to bring up the matter as and when the orders are passed by the apex court. Either way, either of the parties. In view of the interim order, the petitioner can seek a review of promotions which are due to him, since no disciplinary proceedings are as at present pending as against him. You can see. Because now the entrustment itself stands state. That is
Right.
extended.
Within a period of, my lord, 1 month or 2 months. I'll make a request.
Make the request. Please make a request. And if it is not considered, then you'll have a cause of action. We've made it clear that you are free to seek review. What further? Yes. Police constable selection, sports quota, vacancies. Is there another matter on the,
Totally, two
Yes.
posts of,
just a moment, just a moment.
Last occasion, I was counsel for the petitioner who directed to supply a better copy.
no, supplied, madam. On Monday I supplied, I got the acknowledgement also. I got the acknowledgement also, a clear copy.
Is item number 9 also pertaining to the very same selection? That's also sports quota, police constable, civil? No, it's not the same selection, not same selection. Yes. You don't have a copy. List on Tuesday.
Please.
What is the age criteria? What was the age criteria provided in the notification? Though something is said about the age,
No,
We don't fight.
ages means they are rejected only on the ground that suppose if two persons of same, secure same marks, a person who is older than that, he will be selected.
that is all.
That,
Not
that's
the-
all.
Not the age criteria.
No, not on that criteria.
Yes. Tuesday.
Typically, not.
Even they don't dispute that.
Anyway, Tuesday.
That's may I request for a short password?
Charge memo under challenge
Yes, may I request for a password? Senior is on election quota number 1.
today. May not be possible today. We'll have it on next week,
Tuesday, my lords, may I- emergency.
Wednesday or Thursday.
No joke.
Therefore, petitioner, my lord,
Suspension.
suspension, your lordship directed the government advocate on 19/6/2024, prima facie satisfaction of the government to get instructions.
Disproportionate assets case.
And your lordship, my suspension is possible solely on the FIR, that FIR came to be stayed by this court, your lordship. I
Yes,
produced it.
what do you say?
Solely based on.
Appears every year he is required to submit, as per the conduct, cases conduct rule 24. He has not done that. However, but, I've noticed that it is not.
In fact, I have furnished all my, every year, your lordship.
Admit. We've heard the learned counsel for the petitioner as well as the learned government advocate appearing for the respondents. The
Suspension order, your lordship gets at page 202, annexed 810.
It is submitted by the learned. counsel appearing for the petitioner that. Annexure 810 not.
810, your
Order of
lordship.
suspension has been rendered on the basis of the FIR registered against the petitioner. It is submitted by the learned counsel that the FIR registered against the petitioner stands state, which is the order of state?
Page 15, 59, your lordship.
State by court
Dated 6/6/24, your lordship.
in WP number 8838 of 2024 by order dated 6/6/2024. Having considered the contentions advanced on either side. And in the of the facts stated above, we are of the opinion that the petitioner is entitled to the interim relief as sought for. Will accordingly be a stay of the impugned order, of the order impugned before the tribunal at annexure 8. The petitioner shall be reinstated provisionally and subject to further orders in this.
Much obliged.
My lords, in serial number 7, I appear for the petitioner.
Yes.
My lords, this is a matter challenging the transfer, my lords. It's an order of the KSAT where the respondent number 4 was the petitioner and she challenged the transfer, my lords. I was transferred to 19th Circle. She was already working over there. Now, my lords, the tribunal has said that reasons are not provided, although Chief Minister's approval is there. My lords, this is already covered by the decision of your ladyship in Shekharappa's case. Now, my lords, during the pendency of this writ petition, there has been a subsequent development where at the instance of respondent number 4, who opposed the transfer out of 19th Circle, now she has been transferred to 28th Circle. And my lords, another gentleman has been posted to the 19th Circle even as my writ is pending. But of course, it's subject to outcome of this writ petition, my lords. I'm producing that order with a memo.
All this is within one office?
Please, my lords, one office only. The same office building, same office unit, same work from 2011. All these the petitioner and respondent number 4 and impleading applicant are working in the same building, my lords.
have no difficulty working in 19 or going back. But today, if I go back, my tenure is completed there. Then again, I will have to please protect me either there or here. I have no difficulty. It can't be.
I'm the applicant before the Honorable Tribunal, my lords. With utmost respect, my lords, in case there is any grievance, my lords, the present order which is passed, my lords, that may have to be independently challenged, my lords, because what is challenged, what was challenged before the Honorable Tribunal, my lords, it has spent itself since I have moved out, my lords.
When were you posted in the place that,
Pardon me, my lord.
when were you posted?
At
19th Circle.
At 19th Circle, my lords, I was posted on 23/7/2021.
Where were you before that?
Before that, my lords,
My lords, may I request you to see para 3 of my writ petition? I've narrated this, my lords, respondent number 4's postings, all in Bangalore from 2011. Para 3 of my writ petition.
Yes, 2011 onwards, you were in Bangalore itself.
yes.
And what is the finding? What is the finding of the?
My lords, the finding of the tribunal is that the permission, initially, my lords, the submission that was made to seek an interim order was that there is no approval sought by the chief minister since it's a premature transfer. Thereafter, my lords, when the parties appeared and it was brought to the notice of the learned tribunal that there is permission given by the chief minister, the only reasons given are that there is no specific reason given for this particular transfer, and a general reason regarding public interest in administration is not sufficient. Although I've cited Veena H's case, Manoj, your lordships are aware that has been brushed aside. Kindly see page 23, inked page 42.
Yes,
So far as I am concerned, my lords, I haven't been moved already outside. Insofar as my posting to the subsequent place, my lords, which is at now to 28th circle, my lords, that cannot be affected by the instant writ petition, my lords. The instant order which is under question. What is under question, my lords, is my transfer from 19th circle, my lords, to 43rd circle, my lords.
yes,
This was questioned before the honorable tribunal. my lords.
yes.
That has been set aside. my lords. Now I was continuing in the 19th circle. my lords. During the pendency, my lords, I have been moved from 19th circle to 28th circle. my lords. Now I have reported at 28th circle, my lords. I am continuing, my lords.
You understand that?
Yes.
From 2011, you are continuing in Bangalore itself.
Yes, my lords.
There is no allegation in the application with regard to any specific reason for which you are moved nobody else is a party. And there is no allegation of malafide making anybody else a party also. Yes.
So therefore, my lords, now, my lords, I will be left without any posting. my lords. The present order which is passed, my lords, transferring me from 19th to 28th circle.
We are not considering that. We are considering this writ petition
I have
and the
been-
order.
Now what has happened is, I have been moved, my lords, to
R4 was moved from 19 to 43,
from what? Yes, Lord,
from 19 to 43.
That
That was struck down. That was struck
stayed,
down.
And I continued in 19.
Hmm.
Now, as on the date of filing of the writ petition, I was in 19 months.
Hmm.
During the pendency of the writ petition, I was moved from 19 to 28 months. Now, one Mr. Nagarajulu has
Hmm.
come to 19. I am no longer in 19.
Thereafter, from 19 to 28,
28. I am in 28.
you have no objections.
I have no objections. I have
Yes.
moved out.
And you,
I was in 28.
you have come to 19.
19. Now, my lord, any order passed here.
And where are you?
My lords, I am now in 43rd. My lords, kindly see, my lords, I had already taken charge in 19th circle.
I'm sorry?
Kindly, I had already taken charge in 19th circle when the respondent number 4 got a stay. Kindly see page 167 of my writ petition. I was relieved from 43rd. I had taken charge in 19. A writ petition comes to be filed on the same day as the transfer order.
Yes. Now, what is your objection to working in 43 or 19 or wherever?
My lords, I've been in 43rd circle from the last more than 3.5, 4 years now, my lords.
You are liable to be moved out now.
Please, my lords, and I was already moved to 19th circle. And because of kindly appreciate the conduct of R4, my lord, she stops my transfer to 19th, then makes a request to get transferred elsewhere. In all of this, I'm given a fait accompli before this honorable court and the tribunal.
There is, my instruction is, my lord, that it is not at my request. my lord. I have not made a request.
Kindly see the order, my lords, or produced it with the memo. They say transfer allowances will not be provided because it's on demand.
My instruction, my lords, I will file an affidavit.
My lords, kindly see the memo my colleague has handed over today. At page 4 of that memo.
R4 is the first person?
Is the first person who is petitioner before KSAT. And my lords, Mr. Govind Raju's transfer is subject to the outcome of this writ as stated in the order. So he has no vested right simply by virtue of taking charge. I had also taken charge. Kindly see 167 of my writ petition. I was relieved and I had taken charge.
When?
My lords, on the same day of 15th, kindly see, my lords, page
After which
160.
there was an interim order.
There was an.
On the same day, there was an interim order. And the interim order was granted on the ground that there is no chief minister approval when in fact there was. It was not on the ground that there were no specific reasons. The respondent number 4, with due respect, misleads the tribunal, seeks an interim order, stalls my transfer, then requests to go to another place. Well, lords, there's no sanctity at all to any orders if one of the incumbents is able to conduct herself in this manner, my lords.
Serious objection, my lords, to the statement, my lords. There was no misleading. The interim order passed was on the ground that there were no reasons recorded. It is not on the ground that there is
Yes.
CM's approval.
Yes.
If, my lords, there is a contention regarding the transfer being at my request, my lords, I'll file an affidavit, my lords, to that effect, my lords. My lords may grant me time till Monday.
Stated in the order itself. Now the-
My lords, my,
Every 1928.
When you are moved to circle number 28,
Circle
my lords, on 8/7/2024, the order is in the memo. My lords, my only request
Just
is
a
if I
moment,
can.
just a moment, Council. Yes.
More stability, because again, we are liable for transfer. My submission is that at least in the interest of stability of the ground. I have rightly or wrongly been to 90. Of course, I don't mind going back to 28, but ultimately, if I have to discharge duties until then, I have to take up, because we have quasi-judicial function under the Provident
Correct.
Act, gratuity and so on and so forth. I can't discharge those duties also, because I am liable again either to go back or go better. Therefore, my only request is this, if it's possible, then I'll have to go back to 28 on. My request is that anyway, all of us are in Bangalore. Therefore, in view of the subsequent development, I don't think that we should be very for your lordship. And for the petitioner to be accommodated at 93 or less than that.
And since the petitioner, my lords, has already completed tenure, my lords, and transfer is in progress, my lords, it is always available, my lords, for them to request for a transfer and have a fresh posting, my lords, since the transfer season is in progress. So therefore, my lords, it would not warrant, my lords, two other people, my lords, to be disturbed. And I have been transferred during the general transfer season, my lords. When I had initially questioned, my lords, that was beyond the transfer season. That was not in the transfer period, my lords. Now, my lords, I have been transferred in the general transfer season.
so 8/7 order is after completion of tenure.
Pardon me, my lords.
It's 8/7 order is after completion of tenure.
And this is
Not
not
on
on my
any-
request also.
This is not on anybody's request. It is on the general transfer period. It should not be correct, my lords, to say that I have made a request and that I have been transferred and that I am trying to disturb the.
There are only two persons transferred.
That's between the impeding applicant and the present respondent number 4. He is posted to my place, I am posted to this place.
There are separate other
No,
orders, my lords, in respect of other offices.
Petitioner now wants to come to the same place as 90.
No, if it's an excel,
For your either protect me there or here.
Yes.
My impeding applicant.
My lords, may I suggest that, my lords, I be permitted to continue in 19th circle as I had taken charge, my lords, and 28th circle, I'm not concerned. It'll only be the question of Mr. Govind Raju, my lords, he may be accommodated elsewhere since he has been transferred during the pendency of the writ. And he's been made aware in the order, my lord, so.
reading about.
Completing application.
My posting to 19 is not.
Yes,
I
reserved.
don't want to be made a scapegoat for the litigation of.
Yes, we'll consider.
My lords, I'm also relying on Shekharappa's case, my lords. My colleague will pass on the copies.
Yes.
I'm deeply grateful, my lords.
Reserved. Reserved.
My only submission was that the matter is academic and may not require any interference
Let us see.
in view of the subsequent development, my lords.
Yes.
So, leave it with us.
My lords, my only response to that is, until and unless your lordship set aside the order of the tribunal which holds me not entitled to go to 19th circle, I will not have any locus standi to go anywhere else. It's easy for my learned friend to say you challenge it separately, but I'm in this situation at the instance of R4.
Reserved, Council.
I'm grateful, my lord.
Yes.
For the petitioner state in this.
8 years of continuous service.
That's the
Confirm.
issue. In fact, there is another writ petition vis-a-vis the police service, the IPS. Could the matters be taken up together? But this is writ petition number Five nine-
Parameter as far as the other regulation is concerned. Therefore,
590.
coming
Anyway,
together
they've just given me a statement of objections. They've just served me a copy. In any event, my lords, that matter was heard. It was released from part head. Both could be taken up together. Your lordships could hear them. My lords. Writ petition number 5901 of 23.
5901 of,
23.
yes.
That is entirely, it can be, if my learned wishes his matter to come up, I have no objection, that is his prerogative. But as a separate item, on the same day, we have no problem. But as far as the issue is concerned, I am very clear on that as my submission to this court, that there is no parameterial as far as the provision itself is concerned.
That
Here
was
there
seen
is
on that day.
equivalence in, there's another phrase added to that. Deputy collector, equivalent to that. My lord, my one submission to my learned friend is this, my lord, one request, my lord. Let them produce the post of deputy collector in the state of Karnataka. My lord. That would be enough as one document we place on record before this court. Because my learned friend has not produced a single document which we have filed before the law. Before this, okay. They have also made a wrong statement here with regard to the DOPT, the Union of India, which is already in the process of implementing this order and several other orders of the like.
That's one of them. Now that the
Still
issue
would
is,
be- And I don't see the locus of the state government to raise an issue with regard to interpretation of this particular rule when the DOPT, the Union of India, has accepted the interpretation.
in fact, since that issue is brought up, I didn't want to bring it up. Why these matters may have to be heard together, my lords, is interestingly, the Union of India has contested the other case. Now, it can't blow hot and cold. I don't want to litigate with the Union of India, my lords. It's their rules. If they interpret in a particular manner, let the stand be uniform. If both matters are taken
I'm
together,
sorry,
the
there is no
union,
Submission. DOPT is not a party in that. They did not make the DOPT as a party in that case.
let they be.
Then how do we say that they have accepted it? It's a wrong submission. Replete with, I should not say that at this threshold because we are yet to open it threadbare. But at this stage, I would only say one sentence in the, if my lord sees, page 14 of the writ petition, my lord. As at para 3.5, they say, they make a categorically wrong statement when there is the statement of objection already filed by the Union of India, which says that they are accepting the order, they are accepting the precedential order, they've implemented the precedential order, which originated from the Orissa CAT. Kindly see this, just to point out that we are not blowing in thin air, and what is the consideration? How extraneous and to what extent it is, I think it's old salt also working out here a lot. I would not like to expound on that, but it's highly improper on the part of the state government to even venture into this area. Kindly see page 14. Para 3.5. Last 4 lines, my lord. For the aforesaid reason, it was submitted on behalf of the DOPT in the instant case. In the instant case before the tribunal, if the decision of the CAT Cuttack is to be restricted to the facts of the case. This is a statement made in the face of the statement of objection where they say.
It was
when they
amended
get-
subsequently.
when they get Amended.
It might be a
subsequently,
mistake, my lord, a
then what
mistake.
No, but then have you stated that anywhere? Please say that. If you can point out anywhere in this writ petition that it was amended subsequently, it is amended subsequently, but have you again amended your
No.
statement? That's not there.
Yes, list along with WP number 5901 of 23, when?
I'll leave it to my lords, at any convenient day.
Second of August?
Yes.
May I request, my lord? Let the Union of India, let there be that is by request to this court. Let there be a document produced before this court, it was not produced before the CAT. Kindly ask them to produce a document which says, where is the post of deputy collector in the Karnataka state? Can you throw light?
Let's,
No, we
let
are
us,
putting threadbare.
let us hear the matter before,
Most
Calling
vehement
for
opposition
anything.
to when I'm not even
Yes.
asking for a stay.
yes.
There, that itself shows there's more to it
Second.
than meets the eye. Anyway.
So what meets the eye with you, the state government, why should I repeat that repeatedly?
This is also sports quota.
my lord.
Is this sports quota?
No, my lord. My lord,
Yes.
prior to 1989, my lord, the department, three departments, that is Public Works Department, Irrigation and RDPR were all together, my lord, and vacancies were filled up through PWD, my lord.
Yes.
My lord, in 1989, my lord, Water Resource Department had its own C&R rules, my lord. Subsequently, my lord, in 2008, my lord, the RDPR also had framed its own C&R rules, my lord. But my lord, till 2019, my lord, the C&R, the seniority list published by the Public Works Department was operated to fill up the vacancies in both the WRD as well as RDPR department, my lord. My lord, on 19/9/2019, a decision was taken, a policy decision was taken, my lord, to bifurcate these three departments, my lord. Page 328 may kindly be seen, my lord, where a decision was taken.
Yes.
My lord, a decision, page 328, my lord.
Yes. What was the decision?
My lord, 328, my lord, in the middle, my lord. Therefore, if the RDA department or the Water Resource Department also promote the engineers team, dispute may arise as the seniors are left out and the juniors are promoted. Therefore, till the process of separation of the said three departments from the current Public Works Department is completed, it will not be appropriate to consider the proposal of RDA department and the Water Resource Department. Lord, based on this, my lord, a decision was also taken to constitute an expert committee to, my lord, bifurcate the three departments scientifically and to ensure that there is no dispute regarding the interstate seniority, my lord. Lord, during the process of bifurcation, my lord, admittedly, my lord, the petitioners were all appointed in Public Works Department and the vacancies of the RDPR, my lord, in 2003 and 2007, my lord. My lord, the private respondents were appointed as assistant engineers in 2016, my lord. My lord, during the pendency of this bifurcation process, my lord, a decision was taken by RDPR to place the private respondent under Rule 32 of KCSR as assistant executive engineer, my lord, ignoring the directions issued by the committee and the expert committee constituted, specifically directing that there should not be any promotions to the higher posts. Lord, though they had placed under Rule 32 of KCSR, my lord, and in the teeth of, my lord, the expert committee's decision not to effect any promotions, they were further promoted, my lord, on regular basis as 1/7/2020. Lord, the bifurcation process was complete and our options were considered, my lord, on 20/10/2020.
Yes.
My lord, the seniority list of assistant engineer was published without showing the persons who were appointed in 2016 but who were promoted as assistant executive engineer, ignoring the fact that it is their entry level cadre and their name ought to have been included. Lord, that was our first objection when the seniority list was issued. Lord, ignoring our objections, my lord, a seniority list was finalized without showing the names of the private respondents in the cadre of assistant engineer, on the ground that they were already promoted when we came to the absorbed department on absorption, my lord, pursuant to the option exercised by us. But we were also promoted as assistant executive engineers in 2021. But in the seniority list, once again, in the assistant executive engineer, my lord, we were shown below the private respondents on the ground that they were promoted earlier to us. Right, the grievance was, my lord, 2016 appointees are being promoted during the pendency of the process of bifurcation, a policy decision being taken. We challenge the order of promotion on the ground that the order of promotion is non-est in law. But though the tribunal admits that it is non-est in law, my lord, but proceeds to dismiss the application at the admission stage itself, my lord, on the ground that we were not born in the cadre of rural development and Panchayat Raj department, and therefore we have no locus standi to challenge the promotion of the private respondents.
Just a moment. Where were the private respondents appointed?
Private respondents were appointed in rural development and Panchayat Raj department in 2016. We were appointed between 2003 and 2007 in the.
What was the provision with regard to option and how was seniority to be counted?
Lord, the options that were excised, my lord, were subject to Rule 2, Sub-rule 2 of Rule 2 of the 2008 rules. My lord, subsequently, my lord, an amendment was brought to the C&R rules, my lord, inserting Rule 2, Sub-rule 2 of Rule 2, in the 2021 rules, my lord, absorbing our services in public interest.
From the date of.
Yes, my lord.
Appointment.
Yes.
Seniority is to be.
Yes,
counted.
seniority has to be counted from the date of appointment and it is in terms of the directions
Where
issued.
is that, where is that rule?
Lord, the rule I have not produced, my lord, but the decision that has been taken.
Hmm. Yes. Hmm. Creation of the revised seniority list of A cadre, including the reinstating private responsibilities. The finding is that list is being reviewed pursuant to an earlier direction of the tribunal.
No, my lord, that list was, finally, we were absorbed, my lord, in public interest in terms of the directions issued by the expert committee, my lord. My lord, it is not in dispute that we have to be extended the benefit of counting the past service, my lord, as on the date when we were appointed.
Please read paragraph 8 of the tribunal's order.
Para 8, my lord.
Hmm.
It is the contention of the learned counsel for the applicant that the promotion order 1720 was mollified. This contention is not tenable as at all since the applicants were not at all born in the cadre as on 17/2020.
Moment, there are two paragraph 8s. I'm talking about the next paragraph 8 at page 52. I think
52,
page-
my lord.
Sorry, 9.
Paragraph
Minus
9.
Paragraph.
Please,
9.
my lord. The seniority list 29/2021 at annexure A15, which does not include the private respondent, has been challenged. We have already addressed this issue in the order in the tribunal. My lord, this order is under challenge before this honorable court.
Hmm.
It is pending. They
Hmm.
could not have relied on this, the observation of this honorable court.
Yes, issue notice to the.
My lord, on 18/7/2024, my lord, they are holding a DPC to grant further promotion to the private respondents, my lord. I've sought for stay of all further proceedings, my lord. My lord, on 18/7, my lord, they have taken a decision, my lord, and DPC has already been conveyed, my lord.
18/7.
18. I am informed, my lord, and it has.
Yes, for instructions list, issue notice to the party respondents. Promotions, if any made, will be subject to result. of
Lord, that would, my
verification.
lord, I make me work below my juniors, my lord.
Yes.
My lord, they are going to grant promotions, my lord.
After a week,
My lord, your
Yes,
lordship
sir.
may kindly see, my lord.
they have to be put on notice.
My lord,
Yes.
my lord, my only submission is this, my lord. The DPC is being held today or tomorrow, my lord, and in which event, my lord, I will be made to work under my own juniors, my lord. They are all appointed in 2016, my lord.
Yes. list
My lord, they
after-
have been appointed in 2016. Kindly see, my lord. My lord, I cannot be made to work under my own juniors, my lord.
Please get instructions, take out emergent notice.
My lord, let it be passed on, my lord. Let him seek instructions by 2:30, my lord. Let him seek instruction. He wants to seek his, my lord, if DPC is not held, my lord.
Council, there is a seniority list.
Yes,
There has been directions to revise the list. The revision apparently has gone on. And now to say that there should be a stay of.
they are, no, my lord, they are operating the seniority list which was under challenge before the tribunal, and subsequently, my lord, the tribunal having dismissed our application, the matter is pending before this honorable court. They are operating that seniority list.
You should have got a stay in that writ petition.
My lord, there is already, my lord, your lordship have granted an interim order. Initially, there was an interim order, my lord, not to precipitate the matter since the election code of conduct was there. Subsequently, my lord, that interim order has been made it as subject to outcome of the My
exactly.
submission is this, my lord, in
it's to
that,
come on
for a
record
moment,
also.
my lord, in that case, my lord, we have not, they have not challenged the promotion order of the private respondents, my lord. Here I have challenged the order of promotion, my lord. It is a non-est order. It's a non-est order, my lord.
For the reason why they should
Lord,
be here.
My lord, if that is the case, my lord, I'll be made to work under my own juniors who were appointed in 2016, my lord.
In another department council. Yes.
My lord, I was not in the other department, my lord. I was appointed against the vacancies of the RDPR, my lord. It was a, my lord, combined vacancies that were available, my lord, against which I was appointed. May, may I suggest, my lord?
Yes.
My lord, may I suggest, my lord?
List next week comes.
My lord, for this,
Yes.
my lord, may I suggest, my lord? My lord, I am also qualified and eligible for promotion as executive engineers, along with the private respondents. My lord, let them place me under Rule 32, subject to pending these writ petitions. My lord, at least I will be, my lord, restrained from working under my own juniors, my lord.
Not where the entire seniority is being challenged. Yes, sorry. Yes.
My lord, at least let him seek instructions by 2:30, my lord.
Instructions next week. Yes.
But serial 10, my lord.
Yes.
My lord, this is a matter relating to grant of ACP, my lord.
Yes.
The tribunal, my lord, by one line dismissed the application. My lord, your lordship may kindly see the tribunal's order at page number 16. Page number 16, my lord. After narrating the facts, my lord, your lordship may kindly see para 7. Next, the applicant claims he is entitled to the second ACP in the pay of Assistant Director of Census Operations also. We cannot understand this basis of this claim when, as per his own statement, he has held the statistical investigator grade 2 in the pay scale of so and so. The promotion of Assistant Director of Census came on so and so. Hence, the claim of the enhanced benefit under ACP finally, he was promoted as a PB3, and however, as the claimed MECP, PB4, the GPM, the application is patently frivolous and dismissed. What I am submitting is the claim of the petitioner is that retrospectively pay scale came to be changed. As a result, there are two government orders, official memorandum under which the earlier ACP request to be ignored, and thereafter ACP has to be granted. That your lordship may kindly see at page number Annexure 18. My claim is Annexure 18, page number 52, was my representation given to the authorities as to why I have to give an option for the ACP. So kindly see request for grant of ACP, my lord. While inviting your kind reference to the subject cited above, in continuation of my earlier representation, I may please be permitted to submit the following. Your kind attention is invited to the clarification issued by the DOPT on 9/9/2010. Dated 10/2/2000. As per the DOPT circular, it has been clarified since the new MACP has come into existence from 1/9/2008. Previous ACP applicable to the new pay structure adopted on 1/1/2006. ACP is allowed the existing hierarchy. Also, kindly serial number 1 in the clarification of DOPT dated 10/2/2000, wherein it has been clarified since the benefits of upgradation under ACP are to be allowed in the existing hierarchy. The mobility under ACP shall be in the hierarchy existing after merger of the pay scale. An employee who got promoted from lower pay scale to higher pay scale as a result of promotion before merger of pay scale shall be entitled to upgradation under ACPS, ignoring the old promotion. As the post in the pay scale of 5,800 has been merged in the pay scale of 5,500, 900 to the promotion granted to me in the pay scale should be ignored as per the OM referred to above. This was my grievance. This question, this application of OM were not examined, my lord. Now, my lord, the same question came up before the Madras bench of the CIT, my lord. And that I had, last occasion I was reading the memo along with the judgment which I have enclosed, my lord, that your lordship will kindly see. Memo filed by me on 23 June 2024. Your Lordship, two judgments I have produced, my lord, in that. Of course, the second judgment, my lord, is not, only first judgment is relevant. The first judgment, my lord, dated 14/2. High Court confirmed the order of the CAT, where similar grievances of certain persons who got earlier ACP, but later, because of the retrospective application of the revised pay rules, they were granted the ACP benefit by granting them another page number, High Court order in WP number 33,960. Your Lordship, may kindly see in that page number 9 of the High Court order, my lord. All the applicants have a common grievance in the matter that they were not granted financial application
Counsel,
under
where
the
are you
original
reading from?
ACP. The case of the applicant was that they were all working as junior engineers, LGCs in the relevant
Sir.
point time without earning promotion. In terms of ACP scheme has been granted the first
Hello,
financial
sir.
upgrade.
Sir, pause. Where are you reading, sir?
I am that along with the memo, I have given one judgment, my lord. High Court judgment, High Court of Madras.
Memo dated, memo dated.
Your Lordship got it, my lord. Along with the memo dated 23/6.
Yes.
21, I have filed it. My limited request now is that my request has to be considered with reference to the official memorandum and the judgment of the Madras High Court. I am not seeking for any positive direction because the same said case applies squarely to my case. Tribunal has not examined this aspect, my lord. Therefore, I am requesting that the respondent authority may re-examine my claim with reference to judgment of the Madras High Court and the official memorandum.
Respondents, what do you say? You have instructions in the matter. Is that available? You have a copy of the Supreme Court judgment? What do you say, counsel? The judgment you rely on has been set aside, overruled.
Not audible. Not audible. It's my fault.
What is this? Yes, please make available the judgment of the Supreme Court, counsel. Please make it available. So, yes, or get it.
So Honorable Supreme Court has quashed that judgment which has been taken into.
Serve the copy on other side.
You don't quash, you serve it today itself.
Yes, please get that order. Serve a copy of that.
Will serve it today.
Yes.
Next day. Yes, please serve a copy on the other side also. Please. get that order. After a week.
Thirty-first. 11. Rajshekar, yes?
Pending inquiry suspension order was, my lords, under challenge. This honorable court granted interim order, my lords, by an order dated 22/2/2022. Subsequently, my lords, by an order dated 29/6/2022, this honorable court, my lords, ordered to report at the transferred place, my lords, and thereafter, my lords, by an order dated 7/11/2022, This honorable court once again permitted me to, my lords, attend the counseling for the transfer, my lords, and posting.
What is the post?
Post is, my lords, deputy range forest officer. My lords, they have not initiated, my lords, my instructions are, my lords, they have not,
Till now.
till now, my lords, that is
They
what.
found out, man. That's correct. I've
Correct.
told them that it's wrong on their part not to have initiated.
Yeah, this pending inquiry suspension order is of the year 2022.
Say that
It's deemed
now
to be revoked
he's-
already.
Anyway, he's
He's already in, sir.
continuing in service.
Continue, I mean, continuing in service.
Therefore, we'll close
That
this
is
writ
infectious.
petition. We'll close this writ petition and say that he'll be permitted to continue in service. Subject, of course, if you intend to do anything in the
Now after 2
proceedings?
years. Now
But it
after.
appears, I'm told that, my lord, the government seems to be misunderstanding stay orders and suspension orders to be a prohibition against initiating discipline. I've clarified that point, my lord.
Now in that process, my lords, I am saved, my lords.
Yes, that well, we don't know.
That correct. my
Ultimately, if
lords.
they want to continue the proceedings
That's-
against you and they were waiting for this writ petition to be closed, maybe no, this will be the impetus. We don't know. This writ petition is filed. Challenging the order of the tribunal dated 12/1/2022 in application number 4538 of 2021. By which the application filed challenging an order of suspension had been dismissed by the tribunal. It is submitted by the learned counsel appearing for the petitioner that by there was an interim order passed in this
On 22/2/2020.
2022, staying the suspension, and the petitioner had thereafter been reinstated. It is stated that though the petitioner had been permitted to participate in the counseling for transfer by order dated 7/11/2020.
7/11/2.
And transfer date 7/11/2022. The respondents have not initiated any steps for initiation of disciplinary proceedings against the petitioner. It is submitted that though the order of suspension was dated
4/9/2021.
4/9/2021, till date, no memo of charges has been issued to the petition. The learned government advocate on instruction submits that the facts as stated by the learned counsel for the petitioner are correct, and that as of now, no memo
No
of charges
proceedings.
appear to have been issued. Whilst having considered the contentions advanced and in view of the fact that the suspension had been stayed by this court on 22/2/2022. The petitioner is continuing in service. And since no memo of charges has been issued to the petitioner within 6 months, we are of the opinion that nothing survives for consideration in this writ petition. The petitioner shall be permitted to continue in service, horse the suspension order. This will, of course, this will not stand in the way of the state initiating
that will
disciplinary
virtually-
proceedings.
Virtually giving opportunity for them to, my lords, initiate. If they want, let them initiate, my lords.
The
there
note
will
says,
not be any-
except stating that the petitioner shall be permitted to continue in service, disregarding the order of suspension dated 4/9/20.
Grateful.
We'll stop at that. It's up to you now.
Arjun PK.
I appear for the respondent applicant, your lordships. I have filed an application for withdrawal of the money in deposit. Because it's a money decree, my lord, the decree was to the tune of
When was this last listed?
When the application was filed?
Application was filed on 15/6, my lord, if I'm right. 16/6, I have served, I have sent a copy by post, my lord, because they were, I could not serve it and file it. Thereafterwards, I sent it by registered post. If they have not received, if they say that if they have not received it, I'll send it once again. I'll hand it over.
You received the copy now? How much amount is deposited?
70 lakhs.
Is the entire amount or 50%? He is seeking short accommodation to file statement.
Please, my lord, please, I understand. He has got a right to object.
Counsel for the respondent seeks time to place objections on record. List. After 2 weeks, please file it in the.
Please, oblige.
13, Kumar KG.
Twelve days. Notice has to go. Sorry? No, notice has to go in the delay petition. Because you consider it Emergent notice. to
Urgent
correspond.
notice.
14, Prithvish.
Fire and emergency services matter. Writ petition of the state, my lords, has been filed at last. Writ petition is numbered. It may be tagged along, my lords. WP number 18839 of 24, my lords.
8839.
Of 24. May I just seek one indulgence, my lords? We may be permitted to serve the councils who are appearing, because every copies of the writ petitions will be served in advance, and my lords may fix a date. My lords will go on with the matter.
That can be.
That backlog vacancy matter, my lord, there is some
Yes.
urgency.
Yes, please serve the copies.
Please, my lords, we'll serve it in advance, and it may be connected, my lords, any day convenient to the court.
The learned additional advocate general submits that WP 11839 of 2024.
Lords, 18839, my lords.
18839 has been filed by the state. And that
No.
the advance copies of the said writ petition will be served on the learned counsel appearing on either side in these matters. List these matters along with WP 18839 of 24 on 31st.
31st. Please, please.
In advance, let him serve.
Yes,
We
please.
will
serve
have
in-
it served
serve in
immediately.
advance.
We'll have it served.
Because I believe that they would have there is an expectation only. They would have placed on record all the government orders, therefore, my lord,
Please,
government translation also. That would have.
Yes,
please.
Because my instructing council gave a copy of the Kannada circular, I told I am not able to understand.
yes.
Because entire one paragraph is one sentence,
And that is how it is done always.
so that even advocates do not understand. You would be happy if the clients do not understand, but we are also finding it difficult to understand.
Yes.
Interim order, whatever it is. Interim. Great.
Yes.
Further hearings, number 15, Praveen Kumar Raipur.
Yes, yes. Yes. Yes, what do you say?
It's an inquiry
Basic degree plus degree in library science.
because so kindly see
Who are librarians in government colleges?
Yes. I mean, the other way, first the government library should have been granted the pay scale and then the aided college. No? The aided college libraries have granted the IS. Lot of delay, my lord, that was negative by the.
Annexure one is the one, my lord.
Government law.
So it's also stated as anomalies in the scales of pay of librarians in lieu of this. Therefore, it was considered. After careful consideration, proposals of the Director of Collegiate Education and in amplification of the orders in respect to librarians, government are pleased to sanction the following scales of pay with effect from 1/1/1970 to librarians working in the college libraries of both government and aided under Department of Collegiate Education and the Department of Technical Education, Department of Public Instructions. Those having basic degree plus degree in library science, those having basic degree plus diploma in library science. Those in University Grants Commission scales of pay no reduction.
Rate for this not by repetition.
Hmm.
In the repetition, not the sum for directed to pay the higher pay to the higher. That was challenge in appeal. Appeal was dismissed. SLP was filed with state not SLP was dismissed. Thereafter, not the government college librarians made representation. He was the same scale. That not they have denied that we are not similarly circumstanced. Both are librarians, not work is the same. Now the C&R rules for both is the same.
NDC, my lordship, para 11 of the reply statement, my lordship, they have
Yes,
some concocted documents is referred by the tribunal, my lordship, in it which my lordship CID investigation is going on.
Page number?
In reply para 11, page 4, my lord, para 11. State reply,
statement of objections.
please, my, yes, sir.
Para,
Para 11, my.
government order dated 13th August 1975 seems to be a comparative document. Finance Department also is applying to entrust this issue to CID for investigation which is stage. Said you will not reveal the government order which is questioned as it contains only mistakes.
Basically, when you are the aid for the same condition, that CID inquiry is subject to result of CID inquiry, it is granted.
Which is the order, annexure one?
That one they say not is not correct. The order is granted the pay scale not after the court dismiss SLP. The condition is not, there is an inquiry within COD, subject result of the COD inquiry, pay scale is granted.
Where is that?
That is annexure A4, page 35.
No, where is the order by which it says?
37.
COD inquiry initiated? Not yet initiated.
Was that your contention before the tribunal?
No, attention for the tribunal was there is a delay in the filing the.
He is the pen sitter. Tribunal. The tribunal taken its view, my lord. Para 16 of the judgment, my lordship.
Number 85.
Copy of the government order. The writ appeal they have filed the original of the government order. They only filed the writ appeal, not I released it. Actually, A is the order they filed in the writ appeal.
Number 80, para 13 of the order is.
Sorry.
Para 13 of the K80 order, page number 80.
Soon after the benefit had been granted to the private college teacher, I mean librarians, the petitioners had raised the request. Immediately thereafter.
Within 2 months, now we have raised the request. Next year, A5 now is our request.
Delay and lapses.
Government order was implemented on 19/2/2013.
Yes.
You made a representation on 24/2013. In 2 months.
The para 18, my lordship, kindly see judgment. The cause of
Para?
action, para 18 of judgment, my lordship,
Hmm.
page number 88. The cause of action arises the applicant from the date of appointment as per the C&R rules 27/5/1998. From this said date till date, representation dated 24/2013, also 15/6/2013. The applicant association have not explained the delay of 14 years.
How can that be, Council? The
They say
cause of
not-
action does not arise on 27/5/1998. Cause of action arises
That is why it took-
when similarly situated persons are given the benefit.
if the tribunal took it so that they have considered.
On 19/2/2013, you granted benefit to similarly placed persons.
That is when the
But
cause of
that is
action
my lordship.
arises.
In
This
my
is not-
reply, in para 11, it is clear, my lordship, that is the document itself, my lordship, that is not a genuine. That is why you refer the matter to by CID. That my lordship, CID inquiry will,
Nothing has happened.
no, that is under progress.
The private college librarians who are found entitled on the basis of the very same government order,
Kindly see para
they are drawing the amounts.
that is explained in para 13 of the judgment, my lord, kindly see. Page 80,
What does it say?
judgment, my lordship,
Mm.
page 80, para 13. On perusal of the first respondent state Karnataka, order dated 13/5/2010, rejected the so and so. Yeah,
that there was no recommendation for the enhancement of the pay scale in respect of the librarians working in the junior college, while the recommendation was for librarians degree college. Hence, the order of the year 1975 was applicable to the librarian degree college, and further that the order dated 8/7/1972 prescribing the qualification for non-teaching staff, including the librarians, was for junior college, which was not equivalent to that librarian in degree college. E, the order that the non-teaching staff would acquire higher qualification than what was prescribed, certain benefits when extended were withdrawn by the state. The workload for the librarian in the junior college in the comparison with the librarians in degree college was not different, and that the fourth pay commission did not recommend the higher pay scale for librarian in junior college.
Which is why they are before the tribunal. The workload is the same. That is the finding. Even when the workload was the same, the pay commission did not recommend the higher pay scales for librarians in junior colleges. In both the in both private sector and for government sector, there was no recommendation. But in the private sector, they have sought for and got the benefit. You granted them the benefit on the basis of the very same government order, which you now say is under inquiry. Give them also, you can conduct the inquiry at your leisure.
They said it is inquiry, it is under inquiry. 2024 but inquiry is not over.
11 years, what has happened in the inquiry?
I will pursue with the what stage of the inquiry, my lordship.
Whatever is the stage of the inquiry, that will be applicable to everybody.
For private or government.
You did not, you objected on this very ground. For one set, it was found to be, the objection was not found sustainable. They have been given. Now the very same, there is complete parity. Is there anything on merits that you want to say? You have not raised any such contention, but still on merits, is there anything?
Is my lordship, we taken the contention in reply statement, my lordship.
Yes. Heard both sides. The contention raised in this writ petition is with regard to grant of pay scale equivalent to the scale of pay which has been granted to librarians in private colleges,
Aided college.
private and aided colleges, to the petitioners who are librarians working in government colleges. The Learned Counsel for the petitioner submits that the petitioner is an association of librarians working in government colleges. They have given a list of members and have paid court fee.
Please.
In respect of all such members of the association. It is submitted that the qualification prescribed for librarians in government colleges as well as in aided colleges was a basic degree with degree in library science. The petitioners, the members of the petitioner association who have the said qualifications. It is stated that by Annexure A1, pay scales were prescribed for librarians having basic degree plus degree in library science as rupees 250 to 500. And persons having basic degree plus diploma in library science was fixed at 175, 450. Full stop. The librarians working in aided colleges who were subject to direct payment had approached this court, and this court had directed the grant of pay scales prescribed as per Annexure 1 to librarians working in such aided colleges. though the matter was taken up before the apex court,
Division bench and then apex.
the matter was taken up before a division bench of this court, as also before the apex court by the respondents. The writ appeal as well as the SLP were dismissed. And the state had granted the benefits by annexure A5 order.
A4, I'm sorry, A4.
A4 order dated
19 to
2013. Soon thereafter, the petitioner who represented identically situated librarians working in government colleges had made a representation before the government, which came to be rejected on the ground that they had
They were not similarly circumstanced.
on the ground that they are not similarly situated. They had approached the tribunal. And the OA also came to be dismissed on the ground that the, that they had been appointed in the pay scale of 175,450 in 1998. And therefore, there was delay in seeking the higher pay scale of 250, 500. The learned counsel for the petitioner submits that there was no such delay, and it was only when Annexure 4 order was passed in the year 2013, granting the higher pay scale to librarians in aided colleges, that the petitioners had also made representations immediately thereafter for grant of the higher scale of pay. It is submitted that all the members of the petitioner association have the qualification of basic degree plus degree in library science and are entitled to the same benefit as has been extended to the librarians in private colleges. It is submitted that there is parity in the matter of the work undertaken by the by both groups, and that the petitioners are also equally situated and are entitled to the benefit as sought. The learned government advocate submits that apart from the delay in approaching the tribunal, there is also an issue with regard to the genuineness of Annexure A1 government order, which has been highlighted even in Annexure 4 order of the government, full stop. It is submitted that there is some discrepancy with regard to the order dated 10 August 1970, and that the matter is being inquired into pursuant to. When was the inquiry ordered?
Prior to 2013. Prior.
It is submitted that the finance department had opined to entrust the verification of Annexure 1 to the CID for an investigation.
The OD.
CID.
OD for an investigation, and that the said investigation is pending. Next. It is further submitted that since the petitioners had been appointed as against the pay scale of rupees 175, 450 in 1998, they could not have filed the present application or the OA seeking a different scale of pay. Full stop. Having considered the contentions advanced, we notice that Annexure A1 government order, which was produced along with the application, provides for the scale of pay of rupees 250, 500 for librarians having basic degree plus degree in library science. This was Annexure A1 order dated 13th August 1975, produced as Annexure A1 along with the application. It is submitted that this benefit was not made available to the librarians either in the aided sector or in the government colleges. Thereafter, the Karnataka State Non-Teaching Staff Association and several librarians working in private colleges had filed Annexure 2 application, Annexure 2 writ petition, which was allowed, directing the respondents to fix the pay of the petitioners as in the government order dated 10/8/1975 with effect from 1/1/1970. Though the matter was taken in writ appeal and in SLP by the state, the same came to be dismissed. And Annexure 4 order was passed on 19/2/2013, granting the benefits with effect from 1/1/1970 to librarians working in private colleges. Immediately thereafter, the Petitioner Association has preferred Annexure A5 representation on 24/2013, and further representations were also filed. The representations came to be dismissed by endorsements stating that the petitioners are not similarly situated as the beneficiaries of Annexure A4. It was the said endorsement which was under challenge before the tribunal. Apart from stating that the applicants had not approached the tribunal in time, no objections have been placed on record either before the tribunal or before this court on the merits of the matter.
Taken two contention in reply statement. One is, my lordship, they have no basic degree, and another is, my lordship, they have not questioned the 1970 rules. Kindly see, my lordship, para 5 of reply statement, page number 68.
Filed here.
Please,
Your reply statement filed here.
please.
It is submitted by the learned government
five.
advocate that it is stated at paragraph 5 of the reply statement
And
that
15.
is stated it at paragraph 5 and 6 as follows. Tell me it's what? It's 4, 5 and 6 as follows, stated in 4, 5. In the, having considered the contentions advanced, we notice that it is a specific contention of the petitioner that the members of the Petitioner Association are persons possessing basic degree with degree in library science, all of you. It is further contended that they are similarly situated as librarians working in aided colleges and have the same workload and nature of duties as the librarians who are the beneficiaries of Annexure 4 order. It is further submitted that Annexure 4 also grants the benefits to librarians working in aided colleges, subject to the result of the inquiry, investigation to be conducted by the COD as referred to in the reply statements. In the above circumstances and in the absence of any contention that the petitioners are essentially situated differently from the beneficiaries of Annexure A4. We are of the opinion that the rejection of the request made by the petitioners for the benefits as has been extended by Annexure A4 cannot be said to be proper. Further, the finding that the petitioners who were appointed pursuant to CNR rules dated 27/5/1998 cannot raise a claim for higher pay scale even when identically situated persons are granted the benefit also cannot be said to be an acceptable contention. The petitioners had sought the benefit of Annexure 4 order. Annexure 4 being an order dated 19/2/2013. The claim raised by the petitioners immediately thereafter at Annexure 5 on 24/2013 cannot be said to be belated by any stretch of the imagination. In the above view of the matter, we are of the opinion that the order of the tribunal requires interference. We therefore pass the following order. The order of the tribunal, which is under challenge, shall stand set aside. The impugned endorsement shall also be set aside. There'll be a direction to the respondents to consider the claim of the petitioners for grant of the benefits as has been granted to the librarians of aided colleges and to grant the benefits to the members of the petitioner association who are qualified, who have the qualification of basic degree with degree in library science as has been granted in Annexure 4. The grant of such benefits shall of course be subject to the same conditions as is provided in Annexure.
Subject to outcome of C.
Subject to the same conditions as has been granted. The necessary shall be done within a period of 3 months.
4 months.
3 months from date of receipt of copy.
16, Venkatesh Sarbati.
Is there anything available? My lord, in this case, apart from these arguments, I want to submit one thing because the same thing what my lords have intimated, I have brought to the notice of my clients. However, my clients have taken the brief from me I have given NOC and I have filed my memo of retirement. Kindly that may be considered. A new council may also file the wakalat, it seems.
10 and 11,
Huh?
pleading. Pleading.
Pleading.
That is the issue. Here is my lords. They were all working in earlier in they are ex-service people, ex-servicemen. Yesterday I had argued one matter. They pay the order which we referred to, same issue. Whether their pay is protected or not, that is the issue. Here, while fixing, they are given an undertaking. In the event subsequent clarification issued by the concerned DOPT, they are going to reimburse. The page number 124 is the narration of the statement of objection filed before the Honorable CAT. The issue is covered, members. The order 1986 and subsequent 2010 notification, clarification issued. Here
What
also
is the
similar
post? What is the post held by
social,
them?
social security assistance.
Social security assistant initially, and then subsequently, senior, some of them are senior social security assistant, and 2 of them are not, they still continue.
And therefore, the question is whether they are
Group C or-
CND posts.
But even otherwise, it's more than 5 years, all of them.
Apart from
Last decade, because of the back end that I learned and saw for the.
apart from that, not fixed based on their undertaking. If there is subsequent any clarification, that has been recorded in page number 124 minutes.
Pay revised without notice.
Yes.
This was by 18/8/2017 was the fixation.
Yes.
Excess pay recovery order. Demand
Revision,
notice.
18/8/2017.
18/8/2017 is a revision. When was the benefit granted?
2014, man. 28/7/14. May I read that one paragraph, man?
Yes.
The respondents escalated the issue to higher authorities and acceded to this request of the applicants and resorted to grant of pay protection with a office orders dated 28/7/2014. The respondent, while issuing pay fixation orders, have categorically mentioned that is revision of pay and arrears, page number 124 minutes. Recovery therein are subject to review and adjustment by audit, as also subject to further clarification issued herein after by Government of India. The respondent has refixed the pay by grant of pay protection and released the arrears amount on the strength of undertaking submitted by applicants. That is, in the event of subsequent clarification in the matter, the applicants are required to refund the arrears amount pay will be refixed accordingly.
Thereafter, which is the government order? which came-
Same, next paragraph.
Hmm.
When the matter stood thus, the respondent number 2 has referred the issue to Ministry of Labor and Employment with a letter number so and so,
Hmm.
seeking clarification with reference to para 3(5) of the DOPT OM number 19/3/2009, that is 5/4/2010.
Hmm.
That is, whether the said provision is also applicable in respect of such petitioners whose pension is fully ignored while fixation of pay to such re-employed pensioners.
Hmm.
The respondent number 1, that's Government of India,
Hmm.
with a letter number so and so has forwarded the DOPT OM number so and so dated 5/1/2016, dated 4/7/16, marked as so and so, which the following clarifications were issued. The initial pay of such re-employed pensioners is to be fixed in terms of provisions of Central Civil Services, fixation of pay of re-employed pensioners orders 1986 issued by Department of Personnel and Training with a OM number so and so dated 31/7/19 as amended from time to time. The para 4D1 of CCS fixation of pay of re-employed pensioners orders 1986 as amended with this department's OM number dated 5/4/2010, provided that in such case of ex-servicemen who held post below commissioner or commissioned officer rank in the defense forces, and in the case of civilians who held post below group A post at the time of their retirement before 55 years of age, the entire pension and pension equivalent of retirement benefit shall be ignored. That is, no deduction on this count is to be made from the initial pay fixed on re-employment. Also, in terms of 4A and 4B1 of CCS pay fixation of pay of re-employed pensioners orders 1986 as amended with this department's OM number so and so dated 5/4/2010, the initial pay on re-employment of such pensioners shall be fixed as per the entry pay in the revised pay structure of the re-employed post applicable in the case of direct recruits appointed on or after 1/1/2006 as notified with a section 2 part A of first schedule to CCS revised pay rules to these instructions do not provide for protection of last pay drawn before retirement in such cases. This is a clarification. Before issuing this, seeking the clarification, because they escalated the matter to higher authorities with an undertaking that tomorrow some clarifications or audit objections are raised. This will be corrected.
Question is this, even in such cases.
Yes.
It was not on account of any falsehood committed by them or anything. Therefore, the pay already drawn, can it be recovered is the only question.
The question is, my lords,
The
in this case,
recovery, is there not a specific order with regard to recovery in cases where wrong fixation is done in these?
no, it is not
cases
wrong
like-
fixation, my lords. This is with the open eyes. The applicants were
Is there not an order with regard to barring recovery in such cases is the question. Is there not a general order? Is there? No, not that order, specifically in respect of re-employed pensioners. Are you sure? Is there such an order?
Minutes,
This is what we.
actually, this is entire things have taken place by EPFO. EPFO is represented other council. I don't have any instruction. I am submitting only with regard to central government for the pay orders.
Except the refixation stop. Fixation. Refixation can be reflecting of personality. Because the modification came in the date. I think the date is 2016. Because it's Refixation can be. Recovery, till the refixation in 2016. We are only asking you this from memory because the benefits were granted.
Yes.
But pay protection had been granted. This is not one case. This is all over the country.
Yeah,
This was done. And the clarification from the central government came only in 2016. It is from memory, I'm saying that there is a government order which says that refixation is proper. And because the clarification was in 2016, the refixation should be effected with effect from 2016. There should not be recovery. There is such an order. Will you please?
What,
put it up?
my,
If it is not there, it is not there. I'm only asking you this from
My
memory
seek-
because it is specifically with regard to the pay protection granted without reference to the, no, without reference to the orders that were in force. But the clarification occurred only in 2016. Therefore, the recovery of amounts paid till 2016 has been interdicted by an order of the.
I seek Lordship's indulgence to grant some time. I will take and also see some judgments of the Supreme Court in these types of things
It's no
also.
requirement for specifically on this. If there is a government order, then why are we
Then,
going to
oblige,
judgments?
certainly.
Here, some of them are class C employees. We may have to, even otherwise, the case of class C employees, it will have to be, even otherwise, if the government themselves or the EPFO, if I'm not mistaken, please verify from the EPFO also. If there is an order which says, which interdicts only the recovery, they don't object.
Got
They
it.
don't say that. Yes, they don't say that it cannot be refixed. They're saying that the recovery, after having granted them, even on the basis of an undertaking, the recovery is not justified, is the contention. From recollection, we are saying that.
Certainly, I will lay my hands and try to take instructions from the concerned department.
Yes.
Please.
I may be permitted to retire.
Yes, just after 2 weeks, remove from the partner. Release from the partner and list after 2 weeks. The learned counsel appearing for the respondent seeks time to get instructions whether.
Respondent number 1, my lord.
For respondent number 1 seeks time to get instructions whether there are general orders with regard to recovery in respect of re-employed pensioners and the fixation and the protection of pay granted to them. And the protection of pay granted to them. List after 2 weeks.
My lord, respondent number
If
2.
that is done, that is the end of the matter.
I will try to not it. Otherwise, I will
get it.
coordinate the treatment of this. Refers to both Rafiq Mercy and the subject.
And with regard to undertakings also?
Yes,
Yes, list after a week.
next week, Thursday.
My lord, I may be permitted to retire. 2, 3, 4, and 6.
10 days, minimum 10 days is the current number of. Lordship, if he places also, I may have to seek instruction and make submissions.
Next Tuesday. Next Tuesday.
Next
The
Tuesday.
Tuesday. After that. The Tuesday after that. Yes, 30th. 2:30.
Oblige.
Yes, please see whether you can get the.
Yes.
Please see whether you can get the order. Otherwise, we'll consider it on the basis of your judgments.
Oblige.
My lord, my memo may be considered.
Yes, yes, it is accepted.
Accepted.
Yes.
Much.
It will not be.
My name should not.
Alternate counselor.
Alternate counsel is,
Yes, well,
has
EPF.
filed, Pakalu.
I don't think so.
Then notice will, then what?
Shweta Anand is there.
Shwetanand anta ಇದೆ.
Shweta Anand's name is there
Ah.
for R3.
Yes, show them as served. If they don't come, they take the risk.
Much.
Yes. Yes. Memo for retirement accepted. Show the respondents as served.
Further arguments, number 17, Satish K.
Lords, in this matter, though it's listed for further arguments, if I can just, my lords, out of 17 and 17.1, lords have been connected to 17.2, my lords, and I'm sorry, my lords, 17.1 and 17.2 were listed separately. This was with regard to, my lords, PWD and WRD bifurcation matter, where, my lords, some private respondents have been seeking for modification of the interim order with regard to promotions from the cadre of AWE to executive engineer. There was some opposition. Last time, my lords, Prithvish had made a submission that one matter is connected with regard to the seniority. And that matter is listed today, which is at serial number 17. And, my lord, 17.3 also is listed, but it's shown as further hearing. But we had not commenced any hearing, my lords, in 17.1 and 2. It was only for, it says it is for disposal on IA, my lords.
IA for disposal.
IA for disposal, modification.
17 and 17.3 is a different, my lords. Different
Different.
cause of action.
17.
Different.
There is a different.
Somebody had said that they have to. be
Please,
disposed.
No, my lords, I'll say, lords, the main issue in the government writ petition
Hmm.
is with regard to, my lords, the bifurcation, my lords, of the PWD and the WRD. In the connected matters, the consequential issue arising out of seniority list, whether they have to be placed in this department or that department, and consequentially the ranking in one of the, there was a common seniority list. Now that we have bifurcated there is a separate seniority list also. And then with regard to persons of PWD, my lords, shown in WRD department, and that is the issue, my lords, in the connected matters. So connected matters, since it's showing for, I was informed, my lords, that hearing had commenced in the connected matters. But in 17, my lords, point 2, there is urgency, my lords, for modification. In 17.2, there is an IA, my lords, for modification filed by private respondents. As I pointed out, my lords, there was, my lords, the tribunal has gone beyond the pleadings, my lords, and the prayer. And, my lords, granted, my lords, direction to the, in favor of the applicants for directing the state to, my lords, ensure that persons who are recruited in the WRD are retained in that department. Though, my lords, we had given options, my lords, for the purpose of transfer. Now, my lords, this honorable court had passed an interim order staying the entire order. Thereafter, my lords, the private original applicants had made, my lords, application stating that we are going ahead with the promotions. Status quo was granted. Thereafter, my lords, we states sought for modification of the status quo till the cadre of assistant executive.
Just a moment.
My
These
lords, I
other-
appear for the contesting respondents.
These other matters were posted along with it only because the contention was that the.
My lords, they are in fact
challenge is
connected.
only
Yes.
until the post of executive engineer. The other posts are not.
They,
there is
in
no
fact,
contention. But we were told that there are two other writ petitions.
This is,
Yes,
okay?
my lords, I'll-
These writ petitions
So-
where the other.
there is a, no, my lords, I'll submit, my lords.
lords,
So,
Well, I
in
just
in
complete-
serial number 17, what is challenged is the non-granting of interim order by the tribunal in a review petition. That, my lords, I think has become infructuous.
I filed IA.
Now, my lords, he has filed IA also for that.
Yes.
Now,
shall we close?
17 point,
Shall we now
After
close that?
hearing, my lordship, both the matters together.
Hearing the very same submission, this honorable court has continued the interim order and has held that it does not.
Just a moment, just a second.
now that, I'll say.
And get-
Yes, that was.
Both
now-
of them are,
now,
Yes.
as a matter of fact, does there anything survive in that?
please.
Why?
Very same submission was made by the other side.
That is,
No, no.
please, now tell us how does it survive?
The interim in the serial number 17,
Hmm.
this honorable court has granted interim order,
Hmm.
not staying the tribunal's order
Hmm.
by virtue of which we have been promoted.
Hmm.
During the pendency of the writ petitioning in the serial number 17, though there is an interim order of stay, for same not, tribunal has proceeded to pass the final order in review, dismiss the review.
Hmm.
But the submission on the premises that final order is passed,
Hmm.
the present petition has become infructuous is considered by my lords on the ground that since there is an interim order in the present petition, we will be reverted because of the final disposal.
My lords, they,
According to me, no promotions have been made by virtue of either the order passed by the tribunal or they are not yet even promoted at all.
We are
When-
promoted.
They are not promoted at all as an executive engineer.
Those
There
are
are still
on
assistant
facts
executive
anyway,
engineers.
anyway. Hmm.
my lords,
And,
Yes, just a moment.
as it is non-granting penalty for
Hmm, hmm.
But civil petition is dismissed, challenging the original order as well as the writ petition.
17.1.
7.3 is
3.3 we'll consider.
connected. The submission notes of Satish for the last date of hearing, there is an interim order in 17.
Hmm.
So therefore, in case that is disposed of, the interim order will get vacated. 17.3, there is no interim order. So both the matters my lords had adjourned. And then it was heard finally.
So can we,
17
can we do something? We can dismiss 17. The same order which is there in 17, we can make it operative in 17.3. So that at least unnecessary litigations, the numbers at least, so that all your contentions will be saved in 17.3. We'll hear you.
file can be.
Yes, yes, at least.
But there, my learned friend is not appearing.
That we'll say that. Interim order granted in 17 will govern 17.
That appears.
Yes. 17 dismissed as having become infructuous. 17.3. What is interim order
Interim
that
order.
is sought for in 17.3? Heard both sides. There'll be an interim order. Please look at the interim order as sought for till the next date of hearing. Yes. Yes, as sought for till the next date of hearing. As sought for, yes. Well, it will have to be till any other orders passed by this court. You cannot interdict that. Correct. Of course, subject of course to the right of the contesting private respondents to move for variation or vacation of the interim order as found required. Yes. Hmm. Hmm. Hmm.
So far, only thing is, if it could be heard now, so I will comment.
Today, 2:30? After,
There was a modification application. In case it's not possible, then a modification.
My lords, on any day that my learned friend says he is ready, I am ready.
oh, 2:30, I'm sorry. There is a bench at 2:30. We may not be possible. So we'll have it on.
So
Wait.
may I make one?
Yes. Yes.
17.2.
Yes,
I'm appearing for opponents.
yes, yes,
What has happened with the government?
yes,
Even if the government petition is allowed,
yes.
the question of granting stay of promotion also, I respect it. Even if it is, even if the government petition is dismissed
Hmm.
and the application order passed by the honorable tribunal is confirmed on accord.
Hmm.
Question of stay of in both the scenario.
Hmm.
I'm looking at my lord, the petition being allowed or the petition being.
No,
dismissed.
for that,
Therefore,
we'll have to hear the basic facts of the matter.
true, either way,
Yes,
either-
when?
but by respectful submission. level,
Hmm.
On 4 itself,
Hmm.
there was an interim order which says status quo regarding.
Hmm. Hmm.
Thereafter, my lord, the submission made additional education about that. The model code of conduct is imposed till the 4th of June, only till then, they said, that they will not consider the promotion. That was the interim order.
We are listing, matters have to be heard for, even if it is for vacating modification, it has to be heard. So when shall we list this?
Today,
Court's convenience.
our urgency is, my
Court's-
lord, the last 3 months.
At my lord's convenience. Next week, if it's possible.
Say next week. 26th, let us see. 26th. If we don't have the time, we won't take it. 26th, we can
Please,
May I make-
tentatively make a list.
please.
Yes,
may I make one submission?
yes.
You want
26th,
that they have themselves sought the applicants. Is that no promotions will be effected beyond the cadre of executive. Now, if that is given here also, if that clarification is made, kindly see their own interim prayer before the honorable tribunal.
Council, let's
Then
list
beyond
this.
that matter.
It is for that specific purpose that we are listing this. So many councils have to be heard at least even on the question of facts.
No, that apartment, I'm only saying this. It was listed.
If everybody is agreeable to that, it can be,
Yes,
definitely.
that is what learned.
Is it?
I am not agreeing. I am not agreeing at
Yes.
all.
List on 26th. List on 26th.
26.
We cannot get over the requirement of a preliminary hearing on.
So
on-
that apart, my lord.
Yes.
What the respondents, my lord, the applicants before the tribunal, they are already holding the post of superintending engineers and QP. We are now, my lord, holding the post of assistant executive engineers. Even if we are promoted, we'll be promoted at most to the cadre of executive engineers. They are already in the cadre of.
That specifically was the contention last time also.
Before
And
that-
it was specifically listed to here on today. Now it appears that,
Specifically, my lord, to hear on that modification, I
Yes.
kindly see the order.
yes,
It's been
we'll
passed by
hear
the
it on 26th. Yes.
Parted B group, number 18,
I appear for the
RG Hegde.
petitioner.
Amendment,
Lord, my submission is this matter is squarely covered by the judgment of this coordinate bench of this honorable court in 577 of 2000. Not they took time to 577 of 2022. The matter arises this way. The petitioner has applied for a post in that particular manner. He was required to specify his preference.
are you ready?
Please,
It's covered.
not covered. Because in 2011 is concerned, my lord, see, we made separate rules. And also that condition they have accepted and appointed to all the 2011 batch.
Okay. That is so then it will have to be heard. They are contending that it is not covered. You'll hear it.
Yes.
Yes. Not today. After a week. Please give a list. Release it, release it, release it.
This is my lordship.
Yes. Released from the parted list next week,
Yes.
after a week.
This rule will take under. One copy to you.
Please hand over a copy. Yes.
Any specific date, my lord, next week.
31st. 31/7.
And it was not on 31st. First it could have, not there in station.
Yes, 1/8.
B group, number 19, government advocate.
My file is also not there.
Maybe, yeah.
Kind next week, my lordship.
Learned council, learned government advocate shall make available a full set of papers to the learned council appearing for the respondent. List after a week. Not next week, the week after. Yes.
Second. Twenty.
Wait, please. appearing for the petitioners.
Yes.
All these cases, the petitioners were appointed as we are canvassing is this, my lord. Once a disability certificate has been issued, that can be, my lord, appealed. There is a provision for appeal under the act. And disability certificate is issued by the competent authority, by the committee constituted by the government. Now, my lord, as far as the disability certificates issued initially shows that they have the disability. Now, my lord, they were put to retest and resets 3 times. And then the Commissioner for Disabilities cancels it. Now, one is, as far the Commissioner for Disabilities is concerned, my lord, he has only recommendatory powers under the Act. He doesn't sit as a review power or an appellate authority. His reports should be submitted to the government.
Government accepts the recommendation.
Pardon me.
Here, the government accepts the recommendation.
The government cannot, it can be a basis for taking the further action.
Correct.
But, my lords, as far as when a statute provides for a proper mechanism, my lords, mechanism is there is an appeal provided, my lords. Now, as far as the rights of, may I pray the Honorable Court, my lords, the under the Rights of Persons with Disabilities Act 2016, my lords, which has by which the previous enactment is now no more enforced, my lords. By virtue of this, only one provision may, with kind permission, my lord, draw my lord's attention to. As far as the certifying authority for disability is concerned, chapter 10, my lords, provides for the certification of specified disabilities. 57 provides for the designation, my lords, and the procedure for issuance. Here, it is not in dispute that the proper certifying authority issued the disability. There were 3 doctors from different hospitals, my lords. They issued the certificate. Now, kindly see 57, my lords, with kind permission, I beg to read. Appeal against a decision of certifying authority. Any person agreed with the decision of certifying authority.
You're referring to the old act?
No, my lord, I am referring to 2016 Act with kind Rights of Persons with Disabilities Act.
Section?
59, please, my lords. Starts with 56.
Yes.
56, the chapter dealing with that, my lord, how certifying authority to do it. And if there is any grievance, my lords, the 59 provides for
any person aggrieved.
Yes, I do
Somebody-
consider third party can
Suppose-
also do even if
Suppose you were a person,
Yes.
suppose you acquire a certificate
please.
and somebody else, if your certificate were not acceptable, if somebody else would have got, that person would
Yes.
be a person aggrieved. How is the government a person aggrieved? Government is not a person aggrieved.
Not ever. Now here there was a petition by a third party, my lords. Information was given by the third party, my lords. Now, my lords, information was given by the third party, which the Commissioner for Disability acts upon it. My submission is, my lords, the third party in this case, I beg to fairly consider this position, my lords. Third party may be aggrieved because they say they were also applicants for this post.
Correct.
That extent, my lords, my humble submission is, my lords, they have a right of appeal, my lords. Because, but they cannot approach the Commissioner for Disabilities, my lords. May I also beg to take, my lords, to the powers of the Commissioner for Disabilities, my lords. That's in chapter 12, my lord, very next, immediately after this, my lords. Chapter 10, my lords, it provides for the Constitutional Committee.
Not 10,
Uh,
12.
After chapter 10, my lords.
12.
I'm grateful. 12, my lords. 12. Chief Commissioner and the powers of the Commissioner, functions of the Chief Commissioner, 75, my lords. And the State Commissioner, 82. Powers, functions are 80. And as far as these reports are concerned, 83. Annual and special reports of the State Commissioner. State Commissioner submitted annual report based on his
Just a minute. Monitor implementation of the provisions of this act and
Please.
programs meant for persons with disabilities.
My lords, apologies for submission, my lords. The court was not audible till this time. My lords, this is serial number 20, my lords. Apologies for interfering if My lords, my
Yes,
lords,
yes, it is.
my lords, I appear for the petitioner in item 20/2, 20.2. And in item number 20, which my learned friend is submitting, I apologize for my lords, last 10-15 minutes, the court was not audible. My lords, I have filed a petition in 20.2, and in item number 20, we are not made parties. In fact, we are the persons who have been, who were selected having the disability, and we had challenged the same, my lords.
My lord, this submission that 20.2, the petitioner just set the law into motion, gave the information, they were not selected. They gave an information against the persons who selected. That is not in dispute, my lords. Now, as far as that petition, their prayer is, they should be selected. We were not made parties. In the first petition, what I find is.
No, they are parties.
That, uh, 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 have it on another day?
As my lord pleases, we have no objection.
Today, the difficulty is there
please.
are other benches in the
Please.
afternoon. We may not
Please.
be able to accommodate.
Any date, my lords, any date, my lords.
Habitually, we'll circulate
Yes.
the copies,
Please,
exchange the
Yes,
copies.
yes,
Exchange
my lord.
Any citations also, please exchange.
Please,
Please.
my lords, grateful.
That's it.
My lords may give a date that we'll be ready, my lords.
6th of August.
My
Please.
lords, could it be 7th? Just sorry, 7th, my lords. 7th.
In that case also, my learned friend also, I am informed, in point 2,
Yes.
the selected persons are not made as parties subject to what my learned friend says. If they are not made parties, both are required to make parties each other.
We'll do that, my lords. That perhaps may be better because it's the
That,
same issue.
Please, it may be better that you.
It may be
make
better.
Please.
Yes.
Each other parties. We'll
Then
list it on
9th or 10th, my lords, August.
Huh?
9th or 10th August, if
July, August,
Same.
August. Karan.
12th of
12th.
August.
12th, grateful, my lords, grateful. We'll make parties and share
Sorry,
petitions.
13th of
13th,
August.
13th.
Please make each other
Make the parties. We'll do that, my lords.
Please.
We'll do. Grateful, grateful.
Anyone? Government advocate?
Please, no.
Your last occasion, Lordship had directed them to take instructions whether the K2 was promoted or not. Whether there is any disciplinary action pending before.
Matter relating to adoption of sealed cover procedure in respect of the respondent, my lord.
Hmm.
But KT relying on the decision of Chamanlal Goyal, having regard to the fact that there has been delay in the criminal proceedings, has directed that his case for promotion be considered. Against which
What is the charge? What is the case against him?
Lordship may,
I have also relied on
PC Act?
yes, my lord.
Prevention
of
corruption.
corruption.
I have relied on the judgment of the same bench, my lord's division bench, wherein the Honorable Justice Harish has passed an order saying that it shouldn't be adopted.
My lord, the facts are that
Hmm.
there was a charge sheet prior to the DPC being conducted, whereas juniors were promoted.
Hmm.
Now, the KT has categorically said that you have to promote him subject to the outcome of the criminal proceedings. My lord. My lord, the allegations being grave. My lord,
What is the post?
my lord,
He sought to be promoted.
he is seeking
ಮತ್ತೇನ ಇದೆ 5 ನಿಮಿಷ ಏನ್ ಒಂದೇ ಒಂದ್ ಮ್ಯಾಟರ್ ಅದು ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಈ ಬೆಂಚ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಬೇಡ್ವಾ ನನಗೆ ಹೋಗಿಲ್ಲ ಇನ್ನ ಇದೆ
7 in the morning, list number.
Different.
It's just different.
Is, I beg the last pardon, last asked for service particulars of respondent number 2 who worked here, respondent number 4, how many years she has worked here?
Council, please make it available, but we can't,
Yes,
we can't
I will
take
make
it up.
available. I'm sorry, I know that it is a different combination. Grateful.
230. This one, still number 1 hearing on a Shruti C. Changat.
Yes. Do all these matters have to be considered together?
Yes, my lord. May I just make one submission, my lord? May I just be permitted to pass on a synopsis, my lord, just to show how all of these matters are actually similar. I apologize for the state of slight disarray in handing it over, but I will make it good. Yes. Yeah, chart is what I'm also filing, so I may just be permitted to complete my submissions. If my lord would only see, my lord, there are totally 6 matters before, six matters before your lordships today. And out of this, the first 4 matters, my lord, RFA 569, 622 and 947 arise out of a judgment and decree in OS number 922 of 2006. This suit is a suit for declaration and permanent injunction that has been filed by one Sadanand, who's deceased now. He's represented by Zalars against me, Sushilama. The question is whether we are the true owners of the property or they are the true owners of the property. Now, after the suit was filed in 2006, in 2008, a person who was impleaded in these proceedings has entered into an agreement to sell with the LRs of Sadanand, who's the plaintiff in the first suit. He then files a suit for specific performance, which is OS number 926 of 2017. Out of that, 2 appeals arise. One is RFA number 731 of 2023, which is filed by the LRs of Sadanand against the decree for specific performance. RFA number 2029 of 2023 is filed by me, which is a third-party appeal, on the ground that unless it is determined in the declaration, in the appeal arising out of the declaration suit, as to who is the true owner of the land, whether it is me or whether it is Sadanand, there is no question of the specific, first of all, that judgment for specific performance could not have been passed. And secondly, that is in any way, any case subject to the outcome of the
You
first
were not
suit.
party to the second suit.
I was not party to the second suit. The second suit, in my humble submission, my lord, is a collusive suit meant only to defeat my rights. So therefore, all these matters are now tagged together. So there.
Yes.
This will only give a picture about
So copy, please. May I just make one concluding submission? I seek the indulgence of the courts to just make one further submission. In the memo I passed on, I have on the second sheet, I have narrated the suit schedule property in both sets of suits. And my
I don't
lords
think
would
there is any dispute with regard to the fact that the suit schedule property is the same.
the same,
There is
both in
no-
the specific
no dispute
performance
there.
and in-
I'm representing you.
Just a moment, just a moment. Let him complete his.
the chart. What's the original suit notes is 922 of 2006. What's is the first suit
922 of,
2006,
yes.
serial number 1. That is filed by Sadananda. Not seeking declaration that he is the owner of the property notes against one Srimati Sushila.
Sushilam.
That suit notes is decree. Notes against which notes the RFA 569 of 2015
Correct.
notes is filed.
Correct.
And it is being heard notes by the learned citizen.
Correct.
Notes, so far as that aspect notes is concerned, there cannot be any dispute notes where the declaration notes is sought with regard to the title notes over the property.
Yes.
Notes, the other notes suits are concerned. So these notes OS number 926 of 2017. Notes that is pertaining to notes the specific performance where notes the agreement holder notes has sought for specific performance. Not that particular notes,
There the person who's agreeing to sell is Sadanand's
Sadanand.
LRs. Sadanand or his LRs?
Sadanand and thereafter notes the LRs. Now,
Okay.
notes ultimately, so far as notes those suits are concerned, notes ultimately one suit is
specific performance plots has been decreed.
Hmm.
Not that is between the family members of Lord Sadananda and one.
For just a moment, if RFA 569 of 2015 is allowed,
Yes,
then the other suits will have to,
yes.
the other appeals will have to follow that.
In fact, Lords.
If Why are they being heard together?
Lords, ultimately what happens, Lords, is that though Lords, the specific performance suit is decreed, Lords, ultimately it will be subject to outcome of Lords, whether who will be the owner of the property.
Exactly.
It is on the
Let the
declaration.
suit be Lords decided. Where is the question of Lords tagging on Lords?
My only
That
submission,
particular,
my only,
We are
Please
not
continue.
disputing the things
Lords,
where.
ultimately Lords, let these Lords, the RFPs, which are filed Lords as against the
Just for clarity, who are you?
Lords, I appear Lords,
The agreement holder.
agreement code.
Okay, yes, No.
I am the owner of the property for Sadananda.
you are Sadanand's
Sadanand.
Kellas.
I am
Okay.
Sadanand.
What
who
is
has
your,
filed one appeal challenging the very decree in his favor for specific performance
Hmm.
before this honorable court.
Hmm.
So now my suit for declaration against Sushilamma and other three persons who have filed three. separate-
decreed?
My suit is decreed, where in which the court, I do not say that the decree is
Now-
subject to the result
now-
of.
Therefore, it is the primary issue which has to be considered now is with regard to the right of Sadanand over the property.
Yes, yes.
So that RFA 569 will
Yes,
first
please,
have to
yes.
be heard and decided.
Please.
Once that is decided, everything else follows.
Yes.
In the meanwhile, is there any protective order that is required in the matter?
in RFA 569, there is a status quo order. There are
Yeah,
interim
but
orders.
it's orders are there.
Status quo is there.
The honorable
Already
court
an order.
Then why
can
are,
decide 569 first, then
Not
other aspects.
unnecessarily Lords, that 569 Lords.
May I
is
just,
tagged on to this particular case.
may I just make one submission, my lord? May I just make one submission, my lord? The idea, my lord, my only submission,
that is a part-heard matter.
Yes,
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 Has to
part-
go-
my lord, my lord would only consider that in order to avoid divergent findings and multiplicity of proceedings. No, my lord would only see, my lord would, no, my lord would only consider one thing. If it would take no more than 2 weeks to complete the paper books and all of that and all of the matters. All of them may be heard together and a common
be
judgment and
considered-
decree may be passed, my
They
lord.
cannot be going by the roster, they cannot be heard together. RFA 569 of 2015 is a
decided.
part-heard
That is also
matter.
our review.
It will be decided. The others will be decided in accordance with the roster after RFA 569 is decided.
It is to
Please.
be
End of the matter.
followed by the judgment that would be rendered by
Yes.
in 569 one. So that I think all the matters need not to be.
Anybody
brought
else
together,
requires to say
but
anything?
can decide the matter.
Any other arguments?
Are sailing together.
Yes.
May I just make one submission, my lord, with respect to RFA 2029, which is a division bench matter? In that RFA number 731 of 2023 has already been already been admitted and interim protection is granted. If my appeal may also be admitted.
That we can. Yes, we've heard the learning council appearing in these matters on either side. It is submitted that OS number 922 of 2006 was initially filed by one Sadanand as plaintiff as against Srimati Sushilamma and others, seeking declaration and permanent injunction, restraining the defendants from interfering with possession. The said suit has been decreed, as against which Srimati Sushilamma and others have filed RFA number 569 of 2015, which is being heard, which appeal is being heard by a single judge of this court. Thereafter, OS number 926/2017 was laid by Indu Shekhar against the legal heirs of Sadanand, seeking specific performance of an agreement of sale dated 29/8/2008. The said suit was also decreed.
Yes.
As against which RFA number 731 of 2023 was filed by Ratnamma and others.
Lords of Sadananda.
Lords of Sadananda. Full stop. RFA 2029 of 2023 has also been filed by Sushilamma as a third party appeal.
Yes, my lord.
As against the the judgment and decree in OS 926 of 2017. Writ petition number 16102 of 2014 is filed by Sadanand and others.
But this is only to indicate, but the Honorable Court has observed that once the
No, but
original.
the writ petition is not listed.
Not pending.
Don't say that. Don't say that.
No, but the last column, Lord, if your Lordship were to see, Lord, the
Yes.
last column, it says, Lord, the Honorable Court directed the authorities.
Outcome of the-
minimum so and so, subject to outcome of, Lord, the RFP.
That's may not bear in.
Yes. It is further submitted that another writ petition has also been filed as WP number 16102 of 2014 by Sadanand and others with Sushilamma on the party array, which was disposed of setting aside the order effecting the entries in the revenue records in the name of Sushilamma and with a direction to restore the name of Sadanand in the revenue records, subject to the outcome of RFA number 569.
569.
The learned counsel for the appellant in RFA 569 of 2015, as well as RFA 2029 of 2023 submits that the three regular first appeals have to be considered together. However, we notice that RFA 569 of 2015 is filed as against the judgment and decree in OS 922 of 2006, which was a suit seeking declaration and permanent injunction. It is further clear that OS number 926 of 2017 was filed by the agreement holder as against Sadanand and his legal heirs, seeking specific performance of an agreement for sale dated 29/8/2008. Having considered the contentions advanced, we are of the opinion that the question whether Sadanand had title over the property to enter into the agreement of sale dated 29/8/2008 would depend upon the result of RFA number 569 of 2015. However, we are also of the opinion that the said appeal, that is RFA number 569 of 2015, which is a part-heard matter, requires to be considered independently, and that RFA number 731 of 2023 and 2029 of 2023, which arise from the judgment and decree in OS number 926 of 2017, will have to be considered based on the judgment in RFA number 569 of 2000. We therefore are of the opinion that the said RFAs can be separately considered. The RFA number 569 of 2015 is therefore delinked to be heard separately. RFA number, the interim order granted in RFA number 731 of 2023 shall remain in force. RFA number 2029 of 2023 is admitted subject to the objections by the other party.
It has to be
My lord, my.
In that delay has to be.
At the time of filing here. Yes.
2020 already admitted. No, it's
It's admitted.
It's not admitted. Delay has to be condoned.
Delay by big
Yeah.
has to be.
Delay has to be
What
condoned.
is the delay?
This, I think, 257 days, my lord, because when I found out about the decree is when,
How many days?
I think it's 257 days.
275 days, my lord.
Having the last sentence, instead of saying that 2029 is admitted, say that the delay in filing appeal number 2020, the third party appeal number 2029 is condoned, having regard to the averments in the affidavit filed in support of the application for condonation of delay. The said appeal shall also stand admitted subject to the objections on merits by the other parties.
Much better.
That resolves it.
My lord, 622 and 947 of 2015, they're also single judge.
They're also.
That is with 569.
569.
Yes,
They'll with
they'll-
569.
that alone-
I think already.
Because they are the subsequent purchasers from me, so.
Arising out of the same judgment.
It's already clear.
947. Appeal number 6, RFA number 622 and 947 are also appeals pending before the learned civil judge and arising out of decree number 9, the first one, OS number, the first one. My lord, I filed, appeal shall also be sent back for consideration,
My lord,
along with RFA number 56.
I may just be permitted to make good that memo I handed over, my lord, just stitch it in.
orders. List number 1, seal number 36, Vijay Kumar.
Typed copies and translations. 1 week.
Consideration of.
Becomes will see.
37, Subarna Lakshmi.
Lords, I appeal for the petitioner. Lords, insofar as notice to the ninth respondent is concerned, my lords, he's refused hand summons. I've served through email, my lords. I'm just producing the email thread. Even before the honorable tribunal, my lords, he's refused hand summons. At page number 16, if your lordships could see, my lords.
Where did we get ordered? And summons was ordered?
Please, my lords. Everybody else is accepted, except for respondent number 9.
What about his counsel?
He was unrepresented. He refused summons before the tribunal as well. Also. Yes. It's forthcoming from the order, my lords. Page number 16. We can, it is submitted by the counsel for the petitioner that the 9th respondent has refused hand summons in spite of hand summons having been ordered by this court. It is further submitted that copy, notice of the petition has been served on the 9th respondent by email. Please, my lords. And that page number 2, my lords, in my memo, has been produced before this court on the strength of a memo. Submissions are accepted. The notice to the 9th respondent is stated sufficient. Lords, your lordships, kindly one request, my lords. My lords, my translation is ready. Matter pertains to appointment. If a date could be fixed, my lords. Yes. This term.
1st August.
Great.
38. Krishnamurthy Amma.
For the respondent, Keveta, please, minutes.
Petitioner.
Plus, the appeal has been filed in the month of April, 25th of April. There were certain objections raised by the court. Few of them have been complied with. The last one, which is supposed to be complied with, is to bring the power of attorney on record. That can't be an objection by the office at all.
Plaintiff number 4 is the power of
Your-
attorney.
Your lordship may kindly have a look at the judgment of the trial court, in which plus on page number 17, by mistake, Matiraj has been shown as number 4.
All the above plaintiffs are represented by the JPA. But number 4 is.
Number 4, please, the office registration objection. And in addition to the same, please, my lords, the respondent Keveta is 84 years old. Let there be early order, please, my lords.
Yes, the office objection raised is overruled in the light of the submission made by the counsel that the that plaintiff number 4 is not a plaintiff at all, but only the GPA holder of the appellants list. When do you want this? All other office objections are
Yes.
complied with.
If Matiraj was not, was only the.
Monday?
Please, my lords.
Yes.
That's the.
In this case,
Office. And for fifth respondent.
in this,
I approached this.
in the-
approached the honorable.
on 1 minute. In this case, I'm appearing for the respondent number 2226 my lordship. In this case, I'm filing the statement of opposition ready.
And for fifth respondent approached the honorable tribunal minutes, challenging the appointments of the petitioner's hearing and others minutes. Because without properly preparing the seniority list indicator of bill collectors minutes. The honorable tribunal passed the orders minutes by allowing the application minutes. And as per this order, the honorable tribunal, sir, there is no credit to the petitioner's hearing minutes to challenge this order minutes. Can you see page number annexure F minutes? May I read minute? Accordingly, we allow the application and quash the appointment of the private respondents file number so and so and consequent OMs dated so and so. However, until revised select list is formulated by the second respondent, private respondents shall be continued in the said post.
What do you mean by saying that there's no threat? They've been thrown out of their jobs. What further,
So
what,
they have been continued under rule 32 minutes.
until the,
Selection list is prepared, the indicator of
The glaring
bill
mistake.
collectors minutes.
therefore, the question whether your contentions are justified and whether such an order is called for is to be considered
No,
as a
yes.
petition.
The honorable tribunal finally directed this chief executive officer of the Jilla Panchayat minutes to prepare the seniority list indicator of.
That is the subject matter of this.
Yes, there was already a seniority list. There was already a seniority list and a select list,
They did not challenge.
which you had challenged.
No, they did not challenge, my lords.
No.
They did not challenge. They challenged only the promotional orders.
I challenged the seniority list before this honorable court minutes and I have already filed a memo enclosing the order of this honorable tribunal minutes challenging the seniority list minutes. This honorable court minutes has confirmed the order of the honorable tribunal minutes. Therefore, minutes, there is a challenge to the seniority list to the care of a bill collector as well as a challenge to the appointments of the private, the petitioner's hearing.
But it has to be heard.
It requires to be heard.
The non-
Why is the hearing?
Finally, CEO has to prepare seniority list.
That's why-
It's the only grievance before the honorable tribunal minutes. So therefore, minutes, this writ petition does not survive for any consideration. Minutes.
That's why I'm filing the,
Very strange, very strange submissions, my lords.
If the senior,
I am aggrieved by the order of the tribunal and
if the CEO.
why he has filed writ petition, at least he has to make a submission on that point.
and also my lordship, respondent number 234 is consent. I'm filing the statement of objection. I'm ready to.
They have served the copy, my lords.
Please file it in the registry. Yes. So that everybody can Yes, my get a lordship. copy.
Yes, my lordship.
Yes.
Because of interim order minutes, they are not preparing at least a seniority list. Minutes.
That is the question which requires to be heard. Are you ready? Matter can be heard.
I am ready.
Any day, my lords. They have served the copy just now.
Sit on a 1 year date, maybe the week of first week of August. We'll hear it. And also, respondent number 2 already filed the wakalat, my lordship. Office notice not yet filed the wakalat. Please show the names of the counsel for R2. Who's respondent number 6?
Respondent number 6, my lords, is
5. 6 is the private party.
additional private party.
No.
So,
There is
5
a
on
party there before the tribunal.
Hello,
Two, three.
fifth, my lords, is
Petitioner.
only. There is no respondent number 6.
Only 5.
Respondent number 5, 6 and 11, I think before the tribunal.
Here only five respondents. I am the fifth respondent.
Respondent number 5, 6 and 11, they are not.
For the
made part-
tribunal, those are persons you represent.
They are not
If
the
they
parties
don't
here.
want to, if they don't want to come on record, they don't, but should they not be respondents then? Is the
But
only,
we will have to, my
They are
lords.
along with petitioners only.
They will have to be arrayed as. No, lords,
They say with the petitioners only. Minutes.
why? Sorry,
They say with the petitioners only. Minutes. They were respondents before the honorable tribunal.
correct. If they don't want to come on record as petitioners, should they be there as respondents is the only question. If required,
Yes,
because otherwise ultimately they need not say that we were not aware of it. They may have to be made parties as Very well. respondents. Yes, the office objections would be complied with within a week. List pleadings to be completed, list after 2 weeks.
So make them a
were-
party, dispensation.
They were unrepresented, my lords, before the
They
trial.
didn't-
They need not be, my lords, read as
Probably
part.
we can dispense with notice
Dispense
to
with.
them,
Dispense.
but they may have to be made parties. Otherwise, ultimately they will.
Since they did not represent, my lords, even before the tribunal, my lords, they need not be heard, my lords, because they will have to be.
Make them a party. Make
Yes.
them a
They
party.
not be party.
Very well.
Otherwise,
Yes,
for
please.
them to say that it was behind their back.
Please.
Yes. 6th August. Please complete the pleadings also in the meanwhile. If
Very
anything
well.
is being filed, please give a copy to the others.
40, government advocate.
Will furnish the PF. To respondent 5, 9 and
Yes, 5, 9 and 10.
5. Maybe taken up.
On 1/6 and 1/6. I'm also going to accept those data. It can dispense the base. It can be
Yes.
posted by the argument by not the pay email.
Learned
I'm
counsel
accepting
appearing
those data.
for
I'm-
the other private respondents submits that he has been instructed to accept notice on behalf of respondents 5, 9 and 10 as well.
I am for respondents 3, 7 and 9 and 10. I am accepting. For 3, 7,
And 10 also you have filed Wakala? No.
10 of them I'm going to.
3 and 7, you are already on record.
yes, yes.
Yes. Okay. Please see that the wakalat is filed by then.
Yes.
List on 31st.
41.
My lord, I appeal for the petitioner, but the office objection is only relating to translation. Legal question is there, my lord. Because 214 after 5 years of retirement, they have issued the articles of charges, my lord.
Whatever is required, the relevant papers must be available in translation.
Papers are available, my lord. Translations are not available.
Translation, if you are relying on something and arguing on it, please make it available.
No, my lord, I
Must-
will just show from the judgment itself, my lord. I don't rely on because everything is available in the judgment, my lord. Kindly dispense with, my lord.
Yes, just.
And notice may be ordered, my lord, because the matter relating to
It is submitted by the learned counsel for the petitioner that necessary and relevant translation shall be made available at the time of hearing. The office objection with regard to non-production of translated copies is therefore dispensed with. Issue notice.
government advocate for 1 and 2, Lokayukta, third response.
Yes,
A date may be given because, my lord, there is he is retired now, they are holding inquiry, my lord, that's why.
yes, just after.
Date, my lord.
2nd of August.
42. Satish K.
Office objections.
And it's regarding translation. But short point,
Nothing else.
short
Yes.
point is, my lord, matter pertaining to, my lord, retrospective regularization. Persons who are appointed along with us were regularized on completion of 10 years. We are regularized from the date of the order.
When was the date of the order? When were you regularized?
Regularized, my lord. I was regularized
Twenty-one, 6, 2017.
Yes, ma'am.
Immediately you had filed your representations,
Yes, my lord.
approached the tribunal in 21.
My lord, the endorsement was issued in our favor, against us,
Hmm.
challenging the endorsement, my lord. We were before the tribunal. My lord, facts are, my lord, we were appointed in toto, my lord, 30 persons were appointed as geologists.
Hmm.
21/7/1983.
Proper process of selection,
Yes, no. Not a prop,
some selection, no,
no, my lord.
selection, simply a point.
Simply, my lord, posts were available.
Hmm.
We possess the requisite qualification. Posts were notified.
Hmm.
We applied, we were appointed.
Hmm.
Not those are the undisputed facts.
Hmm.
But, my lord, there is no selection process.
Hmm.
My lord, we are not appointed through a proper, my lord, selection.
Hmm.
My lord, in the year 1985-86, my lord,
Hmm.
30 geologists were appointed.
Yes,
Lord, on 10/11/2016, Lord, the first respondent directed to submit the service particulars of all 30, and we will take steps for regularization.
Hmm.
Our name, all 30 names were forwarded. Lord, your lordship will find the, Lord, proposal at page 96.
Hmm.
Page 96.
Hmm.
Lord, serial number 2, serial number 4.
what is the basis for granting retrospectivity to some and not
Yeah,
for others?
Lord, the
The vacancies available.
vacancies were available. As and when vacancy available, they were regularized. Lord, we have been appointed in the year 1985. Lord, they were also appointed in the year 1985. May not be along with us, my lord. I would concede, not along with us. Lord, we were appointed exactly, my lord, on 28/1/1985. They were appointed subsequent to us. Your lordship may kindly note. But 17/2/1986.
Hmm.
Then, my lord, proposal was sent. There were many communications. After Uma Devi, my lord, they were regularized after completion of 10 years. Lord, the order of regularization,
From 1996.
yes, my lord. Lord, is at page annexure A10, 13/12/2011.
Hmm.
Lord,
All their appointments are shown in 1185, 13/185,
yes, ma'am.
21/185,
Yes, ma'am.
not.
Lord, first regularization is, my lord, 22/11/2008. 8 persons. Annexure 8, page 123. Page 123.
Hmm.
8 persons were regularized on completion of 10 years. After 2 years, my lord,
Hmm.
the order of regularization
These were persons who completed 10 years, who were appointed in 1984, who completed 10 years in 1994.
yes.
Hmm.
Lord, the benefit of regularization was withdrawn
Hmm.
in respect of 8 persons.
Hmm.
Lord, by order dated 7/12/2010. Lord, the order dated 7/12/2010 was called in question by 8 persons.
Hmm.
Lord, your lordship will find the facts at page 139.
All that is We understand. Now, the question is not that. What was the reason for your regularization being taken up separately?
They say that the posts were not available. But they admit that in the order of regularizations, we were appointed against sanctioned post. But we are appointed in the year 1985. The retrospective regularization was withdrawn against 8. They approached the tribunal. Tribunal allowed the application, quashed the order and restored the retrospective regularization. Against that, state preferred writ petition, which is at page 153. The state's writ petition was dismissed, affirming the order of the tribunal. Thereby, the retrospective regularization was affirmed. My lords will find the order at page 153. Order of the coordinate bench. Thereafter, my lord, after many communications, we approached the tribunal. Annexure 822, page 202.
Yes.
Page 202 is the order of regularization in favor of petitioners, dated 21/6/2017. Page 202. We approached the government seeking for regularization after completion of 10 years. But the order passed by the tribunal is at page 210. But the application was allowed. Direction was issued to the respondents to consider our request. That is, my lord, annexure 823 is the request, representation.
All of you had already retired also.
Yes, my lord. But the operative portion is at page 221. In the year 2020, my lord, we have approached. Lord, the tribunal allowed the application, directed page 2222, my lord. Directed the authorities to consider a representation for retrospective regularization on completion of 10 years. But again, we made a request on 7/1/2022. Lord, the tribunal, the first respondent passed an order rejecting our request. Page 223 is the order. Lord, challenging this order, the endorsement, we approached the tribunal. Tribunal says that, my lord, it is belated. But the reasoning starts. But the impugned order is at page 49. But the reasoning starts from page 56. And tribunal says that you have accepted the order of regularization dated 21/6/2017. Therefore, you are not entitled. We have not accepted the order of regularization. We were agitating before the para 8, page 56. May I read, my lord? In the light of the oral arguments, we have examined the entire records. Admittedly, the applicant's service have been regularized as per the government order dated 21/6/2017, which is placed by the applicants marked as so and so. On reading the subject and also reference including preamble of the government proceedings so and so, as per the this order, the service of 8 applicants were regularized by the government on the following conditions. The applicants have unconditionally, without protest, accepted the regularization order dated 21/6/2017. In other words, the applicants
Just
Date of regularization.
then, my lord, page 50,
21/6/2017 order is prospective. In normal situations, it is correct. Regularization can only be prospective. It cannot relate back. But in the facts of this case They where are similarly situated. I'll find out, my lord. not I've be, asked them for information. could that not at least be I addressed? understood. Yes,
and
learned.
last
Uh, They are
occasion,
similarly situated. I'll find out.
not the last occasion, my lord, if I'm,
As you are aware of the time it It- takes for the
Please.
government machinery to move.
yes, not,
Learned,
for
government
me, it
advocate
is on,
seeks, you're out of service anyway.
yes.
Now, the issue is if you are entitled to regularize, to prospective regularization, you might get some benefits.
pension.
Learned,
Otherwise, my lord, the old scheme, old pension and new. pension.
learned government advocate. There is no question of any new The- pension. For you, you would be entitled only to PF if,
No.
no,
But suppose I am regularized from
correct. If you're
completion of-
regularized- If you are regularized from the earlier date, you get benefits. Otherwise, it is only 2017 to 2020. You don't even have,
I don't get anything, my lord.
get it.
I don't get anything except PF.
Having heard the learned counsel for the petitioner, we are of the opinion that the contentions raised by the petitioner have to be considered on merits. The learned government advocate seeks time to get instructions as to the reason why there was a differentiation in the treatment meted out to the petitioners and other persons who were other geologists who were regularized on earlier dates and whose retrospective regularization had been considered by this court in earlier proceedings. List after 2 weeks. Please.
But one date. One date, my lord.
Yes. Second,
But let it be for let it be for admission, my lord. They are all,
that is the ultimate argument. a short point, I'll assist the court on the next occasion. I've already written it. Somehow today, they have not given me the file for In whatever reason. normal situations, there is no requirement for a consideration at all. I understood, 30 persons appear to be almost identically situated. but Only the the dates are. old pension scheme came into existence in April 2006, my lord. I don't know whether they will still be entitled to that. I'll find out and make my submission on the next occasion. I'll assist the court on the next occasion.
His apprehension is the matter is listed in B group for final hearing. His name will not be reflected in the cause list.
not me, my lord. That.
Yes.
43, Ashwata Padi.
The result that all his matters are to that way. We get an admission for the beginning.
Your Lordship's kind permission. Kindly recollect yesterday, this is a matter where even a fundamental right is deprived by the second respondent. Even to participate in the examination to be conducted for filling up of the posters, that is a preliminary examination.
You want time to. Yes, the learned counsel appearing for
Lord, this is
the second respondent seeks time to place a statement of objections on record, to get instructions and to place a statement of objections on record. Time is granted, list after 3 weeks. However, in view of the fact that the examination is
Mm.
being conducted?
No, application, examination is being conducted 25/8/2024. Recently, the
The last date for submission is?
last date for submission is 21/7/21.
That the last date for submission of application is 21/7/2024. We are of the opinion that an interim protection requires to be granted to the petitioner. There will accordingly be a direction to the second respondent to provisionally permit the petitioner to submit his application. How will it be submitted? For online submission?
That is only online, my lord. If your lordship gives a direction either online or physically. Online in the sense they have to make a provision in the
Learned
portal.
friend may have a difficult case, my lord, because it's equivalence of a foreign degree. And equivalence as required by the case.
Whatever that be, unless they are, we can't non-suit a person because of lack of, there's. Exactly, which is why the last date is tomorrow. Permit him to make an application, either online or physically. So that ultimately,
Yes.
we can consider it on.
Please, my lord, that is there. We are.
This will not grant him any equity to say that ultimately he is entitled to succeed. That will not. What have you said? There will be a direction to the second respondent to permit the petitioner to provisionally submit his application in pursuance to the notification, either online or by
Physically.
or in the physical mode, so that the rights of the petitioner shall stand protected. However, the petitioner will not be entitled to any, to claim any equity on the basis of the permission to participate in the selection, and the issue will be considered.
A
on the
direction may be accept the application. Otherwise, they may not accept.
permittal, accept the application. Accept the application submitted by the petitioner either online or through, or in the physical. Yes, this should be, the dates, order should be made available to dates. Hand over to both sides to dates.
And office objections may be.
Office objection shall stand overruled for the time being. What were the office objections?
Office objection is the relevant pages I had showed yesterday.
Yes, yes.
My lord,
Office objections are overruled.
yeah, this copy may be made available because.
Will.
Please. And delivery. Please.
44.
The PM, the office objection is I have not produced a translation of all documents, but along with the petition, I have filed translation of the necessary documents. It is submitted by the learned counsel for the petition that the translations of relevant documents have been made available. Office objection is overruled. Matter relates to initiation of inquiry. Let's the appointing authority first appoint the inquiry officer. He is also delegated as the empowered authority. The inquiry officer would issue the articles of charge, to which I objected. That under the specific rules that it is only the disciplinary authority or the empowered authority. Now the empowered authority, first you cannot appoint the inquiry officer and then say that he is also the empowered authority. Even if that is so, he will have to take the approval of the appointing authority and only then issue the articles of charge. To which Shall cause. Here, as in B.V. Gopinath, I relied upon B.V. Gopinath. The tribunal would say, that B.V. Gopinath is rendered in the situation of a CCA rules, whereas this is under the disciplinary police rule. Therefore, that judgment will not apply.
What is the distinction in the rule?
The rule here, says that the appointing authority or the empowered authority shall issue the articles of charge. Now, in any event, the inquiry officer could not have been appointed earlier to the articles of charge being issued or my reply.
Can we see the police rules?
Please. Police rules. Karnataka State Police Disciplinary Proceedings. Police Act. Page 203.
procedure for imposing major penalty. No order imposing on a police officer any penalty specified in subclause so and so shall be passed except after an inquiry as far as may be in the manner hereinafter provided. But may I just pause here a minute? And in fact, my lord, under the Police Act, section 23 specified the penalties. My lord, your lordship might not find it in that book because after commencement of Civil Services Act, the penalty clause under the Police Act was deleted, reenacted under the Karnataka Civil Services Act. But in the books, my lord, it is always deleted. Anyway, now clause 2, my lord, is the procedure. The disciplinary or authority or any authority empowered by it in this behalf, hereinafter in this route referred to as specifically empowered authority, shall frame definite charges on the basis of the allegation.
Disciplinary authority or any authority empowered by it in this behalf shall frame charges.
Yes. Now, let's assuming, my lord, they have the power to frame charge. First procedure is to frame charge. Next, my lord, subclause 3. The police officer shall, for the purpose of preparing his defense, be permitted to inspect and take extracts from such official record as he may specify, provided that such permission may be refused if for the reasons to be recorded in writing. 4. On receipt of written statement of defense or if no such statement is received within the time specified, the disciplinary authority or specifically empowered authority may inquire into such of the charges as are not admitted. 5. The disciplinary authority or the specifically empowered, as the case may be, may nominate any police officer to present the case in support of the charges before the authority inquiring into the charges herein referred as the inquiring authority. Therefore, my lord, the first stage is to always issue the articles of charge. In this case, my lord, they would first nominate the inquiry officer. The impugned order would first nominate the inquiry officer.
Not the empowered officer.
No, the inquiry officer is also the empowered authority now. Under the one order.
Where is that? Where is that order?
That your lordship, my lord, will find at 198, the translation, my lord, would start at page 200. Relevant portion would be, my lord, 203.
Yes.
In view of the above allegations, I, disciplinary officer so and so, have ordered as follows. A departmental inquiry has been ordered under Rule 6 of the Karnataka State Disciplinary Proceedings Rules against the so and so. And the Deputy Superintendent of Police Department Central Zone has been appointed as the inquiry officer and given the authorization to appoint the presenting officer. Now, appointing authority, the inquiry officer is appointed. Next paragraph. Now, there, he would also, my lord, specify that you are the empowered authority, you shall issue the articles of charge and conclude the inquiry within a period of 4 months. Now, my lord, inquiry.
Is there not a slight problem here? Is it not only after the charges are framed, the charge memo is given to the officer, his reply is received? Is it only at that stage that you decide whether the inquiry is necessary or not? There must, innocent until proven guilty is available even in these proceedings to an extent. He must be given a chance to explain. In a given case, suppose you are alleging some grave misconduct against an officer. He in his reply can show that he was probably not in station at all at that relevant date. He can provide material to show. If that is, no, I'm not on this case at all.
Yes,
I'm sorry, I have not seen your defense.
But
I'm only, if suppose in a given case, you say that probably he had, there were arms found in his office, arms and ammunition. If he can show that he was not even in the country as on the date when this happens, or some other such clear denial, which can be verified, then you don't have to go forward with that particular charge. Therefore, is there not, is that not the
order? The inquiry officer is specifically
Then
empowered
that be-
authority is empowered.
understand? If there is a,
Consider and only proceed thereafter. He finds.
is that the, because one step we are completely,
Haven't received the file also.
please look into this. This is the only question. Suppose the disciplinary authority is empowering this person to do whatever is necessary. That is one thing. But to say that the inquiry officer is appointed And the inquiry officer can, in some rules, that is permissible. There are some rules where the charges themselves can be framed by the inquiry authority. There are certain rules, but this does not appear to be one such. At least normal procedure in government service, what normally happens is a charge is framed, the charge is the charge and the statement of allegations are given. His reply is received, that is looked into, and whether it is required or not. What kind of inquiry is required also probably you decide at that stage. If he admits and says that I've done it, but you find that it is only the allegations that stand proved are not true, then probably you can impose a minor penalty also.
See the filing, what the trial court has said on this point may also be considered at this stage.
Trial court has not considered, trial court has simply gone on the issue of whether empowered authority can issue just PV Gopinath versus Union of India judgment.
Empowered authority can. If the empowering, the initial thing is the rules, you probably there may be decisions on the point also, which I am not aware of.
Your Lordship, kindly come to page 237. There is a division bench judgment, my lord. I possibly can't say that right. The page 237, very rules are considered. Division bench would say that it is only the appointing authority which can do it. Para 6, rule 6.1 and 6.2 of the Karnataka State Disciplinary Rules 1965 read as aforesaid statutory provision of law governing the field makes it very clear that the charge sheet has to be issued by the disciplinary authority and not by the inquiry officer. There, they did not consider the issue of empowered authority. Following this decision, the very bench of the tribunal has allowed another application. Anyway, that's a question of law right here.
There is a full bench decision of the Kerala High Court which says in cooperative societies, of course, construing those rules, there's a full bench decision which says that not only the disciplinary authority, the inquiring authority, there is a subcommittee constituted. The governing body, the managing director, the inquiring authority, that is a subcommittee, anybody can issue the memo of charges. So that is going by the language of those rules, which is why we are saying that is
issue or cause to be issued.
Cause to be issued.
Which is interpreted to mean that empowered authority can issue, provided the disciplinary authority approves of it. Now, let's hear whether the disciplinary authority's approval is required, because it is not cause to be issued. It is empowered authority.
Empowered authority,
So, is there a
the disciplinary authority or the empowered authority.
So, will they require the approval of the disciplinary authority before the issue is one gray?
May not be required, because once empowered, again going back and getting an approval.
But
will
cause
be
to be issued
repeating.
is also.
Well, there again,
I understood the earlier point.
there again, any authority empowered by it in this behalf.
Yes.
There must be an not a general empowerment, it's empowerment to conduct the proceedings.
Your Lordship referring to Mattanur cooperative.
Mattanur.
Full bench.
Yes.
It's common. Like
Yes. The judgment is to the effect that anybody can. The managing director, the managing committee, the subcommittee, anybody can issue. Exactly. Even the secretary can issue.
Yes.
But the display authority of the empowered authority will be empowerment is supposed to be. So that
Should be proceed further or not, this will taken back.
now the theater complete. Is all again, it goes by the language of the rules.
Empowered authority can issue,
Can issue.
but the empowered authority's power has to be circumscribed by some facts. Because empowered authority can't issue charges on any and every misconduct.
he can only issue it in respect of what he is empowered to do.
In this behalf. there is the-
In this way.
In this behalf, so the
Therefore, there
appointing
has to
authority
be
will have to
some,
circumscribe
some
limitation.
application of mind in the first place by the disciplinary authority.
Yes.
Now, the memo of charges itself, if the empowered authority, who's also the inquiring officer, is the disciplinary authority doing both this is permissible, can be done. But when you're empowering an officer to be the, well, can the empowered authority now say that no inquiry is required? Is it open to the inquiring authority to now, I mean, the empowered authority? Because he's also the inquiring authority. He's also already been invested with the power to conduct the inquiry. Can he, as a matter of fact, after receiving the reply, say that no inquiry is required, it can be closed?
Holding not guilty.
Can it be done?
My submission of reply then will become an empty format.
He is the inquiry officer and he will present his report to the disciplinary authority.
Therefore, what that
Even if he
that
works in
first discretion to consider whether an inquiry is required or not appears to have been sanctified.
They had the benefit of intermodal.
Yes. It is already admitted. Already admitted.
It's not, no, it has come up for
Oh,
the first
first.
time.
Yes, the office objection is dispensed with. Petition is admitted. Learned government advocate takes notice for the respondents and seeks time to get instructions. List after 2 weeks. Copies are available. The learned council shall make available a further copy of the writ petition to the learned government advocate. List after 2 weeks. In the meanwhile, further proceedings in the inquiry shall be kept in abeyance till the next date is placed. Yes, don't say admitted. Let it remain, otherwise, yes, yes.
Question, still number 21.
Yes.
Pending criminal proceedings against the respondent. The Tribunal gave a direction to consider a case for promotion facing Goels. Where it has been said that promotion cannot be denied.
Yes.
This case, the seriousness of the allegation, after the stay order was granted, it was only in 2021 for the first time it is juniors were considered for promotion. Thereafter, I am told that it has been reviewed thrice. So therefore, they have been following the procedure of reviewing the not promoted. But to that extent, I only competent authority being permitted to review the procedure every time. That has been done three times. Yes, 2021, 2022, and 2023. They have considered and but in so far as 2021 is concerned, it is merely stated that because of the charge sheet being filed in the case, but I accept it to be today. The CH-3 is the opponent. And the bottom page number, first document, page number 7. Respect of Lakshmita C. 934, serial number, Jeshate Kramanam, seniority number 934. The second column 934. Respect of Lakshmi Shah C, it is stated Dinanka 16/2/2016 so and so ಆದೇಶ ದಲ್ಲಿ ಈ ಕಚೇರಿ ಆದೇಶ ದಿನಾಂಕ 28/1/2016 ನೌಕರರನ್ನು ಅಭಿಯೋಜನೆಗೆ ಒಳಪಡಿಸಲು ಮಂಜೂರಾತಿ ನೀಡಿತು. ಪ್ರಕರಣವು ಲೋಕಾಯುಕ್ತ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಾಕಿ ಇರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಮಿತಿಯು ತೀರ್ಮಾನಿಸಿತು. Committee has decided to adopt seal cover procedure in respect of the officer. In having regard to the order dated 28/11/2016, by which he has been subjected to, sanction has been granted for
Prosecution.
But the next order is dated 5. This is the DPC proceedings of 5/2/2022.
Same, the very same. So therefore, there is,
In this they say that we have sought permission from the government to file a writ petition. In the next one, they have said that because the stay order has been granted in this writ petition, we have not considered it stay. But I'll also point out the reason why it is getting delayed. Matter is related to FIR was filed in 2012. Charge sheet came to be filed only in 2017. There was 5 years delay. The reason is that this is a matter relating to prevention.
PCI.
PCI. And because of the plurality of the delinquent officers, about 12 officers, including the respondents, are being investigated. So
And
therefore,
all their promotions are withheld. Is correct.
I've already furnished the copy to her. And I also applied the RTA and got the endorsement from the department. For department inquiry, like endorsement also came from the excess commission.
no departmental inquiry was there, but
It's only the-
charge sheet in criminal.
If the second accused has been promoted, the petitioner also has to be, after the tribunal finds in his favor, why are we holding it up? KC Appanna.
He was a PDO, then he was promoted twice during the pendency of the.
Form that they are from different departments. So the role of each delinquent officer is different. This is not, it's not clearly forthcoming. in any of
KC
the
Appanna is EO, excise officer.
The respondent in this case is the excise inspector.
Inspector of excise.
KC Appanna.
Huh.
in respect- is considered.
PDO.
PDO.
But that is by another,
I'm told, it's not clearly forthcoming from any of the documents, even that which were filed for the tribunal. What is the exact charge? I'm told that they granted a forest land illegally to somebody and the building was constructed and their excise
Excise-
license was given to.
The pendency of criminal case is the reason cited by you.
that is the only reason, that is the only question we are considering. If others who are accused in the very same criminal case are being considered for promotion, the rule is the same for everyone. Rule is the uniform rule for every department. How can you say that
The role of delinquent officer may be.
that is not for the government to consider at this stage. It is for the criminal court to consider. Now, if the rule is the same and certain of the officers are being promoted, why is it being after the
These are-
tribunal
they are
has
belonging
considered?
to different departments, that is what. This respondent belongs to the excise department and Appanna
All that is required to be done is the seal cover is to be opened. And to see whether he's entitled for promotion, at least in terms of juniors who have, or at least prospectively. Since this is pending here, we won't grant him the entire benefits that are due to him. We understand that there is a PC Act proceeding pending. We understand the gravity of the allegations also, but that does not mean that after the tribunal has considered and found in his favor, and other officers who are the accused in the very same crime are being promoted.
Competent authorities are different and independently they have applied their mind.
Exactly, the rule is the same. If, as a matter of fact, because you are, there is no provision in your rules with regard to DPC or to seal cover procedure. These are only executive orders.
Government order.
Therefore, if it does not apply to A, it should not apply to B also. Those rules have to apply uniformly to everyone. Shall we take note of this and say that other accused have been promoted? Or do you want to get instructions on this aspect of the matter?
But clarified that
It is
he's from a different department. Maybe
heard as an interim order.
there is an interim order.
Yes, we'll modify the interim order only to that extent. Provisionally to consider his promotions. Taking note of,
Prospectively.
open the sealed cover, provisional promotions and prospectively.
Alternate bench also is passing or disciplinary. Niranjan Lakshay, passed by the Justice Harish Kumar and Playing on Tamil God is this very important.
Heard the Learned Council for the Learned Government Advocate appearing for the petitioner as well as the Learned Council appearing for the respondent. The Learned Council appearing for the respondent submits that in view of the interim order granted by this court in this writ petition, the promotions of the petitioner from 2020 onwards are being held up on account of the fact that he has figured as an accused in a criminal case under the Prevention of Corruption Act. It is submitted by the Learned Council appearing for the respondent that persons who are co-accused with him in the very same case have been granted promotions in their departments. Full stop. It is submitted that it was after considering the inordinate delay which has occasioned in the completion of the proceedings before the criminal court that the tribunal had directed the opening of the sealed cover and the grant of promotions to the respondent. It is submitted that the tribunal had placed reliance on a decision of the apex court in state of Punjab and others versus Chaman Lal Goel, and had found that the promotions cannot be held up indefinitely on the ground that the disciplinary proceedings have not been completed. The Learned Council would also place reliance on a decision of a coordinate bench of this court in writ petition number 200561 of 2022, dated 14/7/2022, to contend that the delay in considering and a delay in trying and disposing of the criminal case cannot visit the employee concerned with the serious consequence of denial of promotional prospects for unduly long periods. Full stop. The learned ground pleader submits on instructions that the co-accused of whom reference is made by the learned counsel for the private respondent was working in another department, and that no promotions have been granted, overlooking the pendency of criminal proceedings in the excise department. Full stop. Having considered the contentions advanced, we are of the opinion that in view of the fact that the criminal case was registered when? In 2012. And since it is an admitted fact that the trial has started? Sorry? And since the charge sheet was filed only on 12/6/2017, and the trial is yet not complete, the
my submission that the delay is on account of plurality of accused.
a complete stay of the order of the tribunal is not warranted in the instant case. Though the learned government advocate submits that it is only due to the fact that there were several accused persons, accused government officers of 11 government officers from several departments involved in the crime, that there has been a delay in concluding the trial. However, the vote is submitted so and so. We are of the opinion that the issue requires a consideration. The learned counsel for the private respondent also submits that the accused number 9 is also a government servant.
Yes, ma'am. He's the one who was given permission to extended the license.
Accused number 9. Please hand over. The accused number 9. What was he working as?
He was deputy commissioner of
The accused number 9 in the case. Who was the deputy commissioner of Kodagu district, had approached this court, filing with petition number 36563 of 2017, and by judgment dated 12/6/2023, the charge against him stands quashed. Be that as it may, we are of the opinion that in view of the fact that the tribunal had considered the contentions advanced on either side and had directed the consideration of the promotions of the petitioner, the blanket stay order granted by this court cannot be continued indefinitely. In the above view of the matter, there will be a direction to the respondents to open the seal covers in respect of the petitioner and to provisionally grant him promotions prospectively to the post of Deputy Superintendent of Excise, subject to further orders in this writ petition. The necessary shall be done within a period of 3 weeks, 4 weeks from date of receipt of copy of the order. 4 weeks from today, we'll make available the copy of the order tomorrow.
Serial number 45, my lord, I at least get a date, my lord, because it's a pension matter 45, my lord. Tuesday or Wednesday, my lord. State appeal.
Tuesday or Wednesday may not be possible. A Tuesday and Wednesday is possible, but not next Tuesday or Wednesday.
Yeah, subject to convenience your next week, any date. Your.
Another person is claiming parity, that is dismissal subsequently. This is the case for reference to 30 number.
Just after 2 weeks, we'll consider.
7th August. 7th August,
Obligement.
24. Vijay Kumar.
Yes.
8th August. 25, Srinivas SP.
Yes, who appears against you? State and KPSC. Is PSC represented? KM Prakash. Appointment to the post of?
My lord, headmaster or mistress of the schools. My lord, the Karnataka government issued the notification for appointment and provide 30% reservation to women candidates. The appointment was in excess of 30%. So some persons they put the Supreme Court, including some of us, we appealed the Supreme Court, and even we initially filed a writ petition. The Honorable Supreme Court said there's already one matter pending before the Supreme Court. So this was dismissed with an application that we should move an impleading application. Impleading application was filed. And the Honorable Supreme Court considered the matter in the main matter and granted relief in the main matter. And in that matter, Honorable Supreme Court said, as far as the reservation is concerned, this reservation to women is the form of redundant reservation. It cannot exceed the limit prescribed, 30% it cannot exceed. It should be only the total should only be 30%. What was done was, so 30% in each category it was given and it practically exceeded much more, 100 or 61 more appointments were made. More appointments were. So the Honorable Supreme Court said the person who has come before the Honorable Supreme Court, merit-wise he is more, his rank is more, he should be accommodated. And then the Honorable Supreme Court also considered.
Can a reservation result in denying of appointment to a meritorious person? Only because there is a reservation provided. Suppose there are more number of candidates and they have higher merit than the others in this election.
My lord, here the case was 30% was reserved. No grievance about 30%. And what happened was, my lord, the number of posts given to that category was more than the reserved category. It was a calculation error by the KPSC and the concerned. What they did was, my lord, as the women reservation should have been, my lord, should have been accommodated in each category, the total should have been 30%. 30 or 33%. What they did was, they considered it as a horizontal.
Suppose there are more women.
Please, more women.
More women.
Please.
Who have secured positions in the select list.
Please.
Can they be denied appointment saying that there is a reservation of 30%?
Points, my lords, have been considered in Rajesh Kumar I produced it annexed page 44. The exact situation where in the judiciary it happened so, my lords. And the question before the Honorable Supreme Court is, can it be in excess? Because the argument was this, my lords. For example,
what is the purpose of a reservation?
Reservation, my lord, there is a distinction between reservation in 15, Article 15 and Article 16. The Honorable Supreme Court is laid out in Rajesh Kumar my lord. As far as Article 16 reservation is concerned, my lord, that is vertical reservation. As far as the reservation for handicapped persons and other special categories, it is always horizontal.
Correct.
And the Honorable Supreme Court said, as far as the reservation for women is concerned, that is under the Article 15(4), my lord, and it should be horizontal. Yes.
When it comes to vertical reservation, the socially backward classes will compete first against general category. Thereafter,
Correct.
So far as vertical reservation is concerned, they will first compete against the reservation.
Thereafter, they are found to.
Horizontal.
There are more, first there is competing against the post reserved,
Correct.
as opposed to vertical reservation when there is competing against women. So the example in fact given in Daria's case is, there are 100 posts and 30 posts are reserved for women. The 100 posts will be, candidates will be listed against the 100 posts as per the merit. And the court will, and the appointing authority will consider how many women are there in 100 posts. If there are 30 already there, they will not take anybody, anyone more. If there is less than 30, then they will remove the lowest ranking from that category, from that particular category.
Somebody-
That is They read that, Rajesh Kumar Daria, my lords.
Then do away with the reservation.
Let me put this.
Because the reservation in that case creates an embargo. If that is not the intention of a reservation. Be it for physically handicapped persons, be it for women, for whatever the reason.
This distinction is made, may I read you the words of their.
Woman
lords?
selected in a general merit category, if she is a topper, how can you say that she has been selected based on reservation?
Intention is one.
Not based on reservation, based on merit.
Horizontal reservation is concerned, but what the Honorable Supreme Court lays down, my lord, of course. Philosophical thoughts, my lords, there are two other views also possible. The distinction is made between horizontal and vertical, my lord. May I read those exact sentence for the Honorable Supreme Court?
Please.
Page 4, my lord, starts at page 44. And, before para 6, before examining whether reservation for native women had been correctly applied, the advantages refer to the nature of horizontal reservation and the manner of its application. Indra Saudi, horizontal reservation was explained thus, all reservations are not the same nature. There are two types of reservations, vertical and horizontal reservation. Reservations in favor of SC, ST and other backward classes found in Article 16(4) may be called as vertical reservation. Whereas reservation for physically handicapped under Article 16, clause 1 can be referred to as horizontal. Horizontal reservations cut across vertical reservations. What's called interlocking reservation. To be more precise, suppose 3% of vacancies are reserved in favor of physically handicapped. This would be a reservation related to clause 1 of Article 16. The person selected against this quota will be placed in the appropriate category. If he belongs to SC, he will be placed in that quota by making a selection. Similarly, if it belongs to open competition, OC category, he will be placed in that category by making a selection. Even after providing these reserved reservations, percentage of reservations in favor of backward class remains and should remain the same. Para 7. A provision for women made under Article 16(b) in respect to employment is special reservation as contrasted with the social reservation under 16(4). The method of implementing special reservation is a horizontal reservation, cutting across vertical reservation as explained in Article 1.
Yes.
Please. Anil Kumar, para 7, the proper correct course is to fill up the OC quota 50% on the basis of merit, then fill up each of the social reservation quotas SC, ST and BC. Third step would be to find out how many candidates belong to special categories as is selected in the basis. If the quota fixed for horizontal reservation is already satisfied, in case it is an overall horizontal reservation, no further question arises. But if it is not so satisfied, requisite number of special reservation candidates will have to be taken and adjusted or accommodated against their respective social reservation categories by deleting the corresponding number of candidates therefore. If however, in the case of compartmentalized horizontal reservation, then the process of verification and adjustment or accommodation as should be applied separately to each of the particular reservations. In such a case, the reservation of 50% in for the special categories overall may be specified. Para 8, we may also refer to related aspect before considering. First is the description of horizontal reservation. For example, if there are 200 vacancies and 50% is a vertical reservation or SC and 30% for horizontal reservation for women, proper description of the number of posts reserved for SC should be for SC 30 posts, of which 7 posts are for women. We find that many a time this is wrongly described. Thus, for SC 21 posts for men, 9 for women in all 31 posts. Obviously, there is and there can be no reservation category for male or for men. The second relates to the difference between the nature of vertical reservation and horizontal reservation. Social reservations in favor of SC, ST, OBC and 16(4) are vertical reservations. Special reservation in favor of physical handicap, women, etc. under 16(1) or 15(3) are horizontal reservations. When a vertical reservation is made in favor of backward class and 16(4), candidates belong to such backward class may compete for non-reserved posts. And if they appoint the non-reserved posts on their own merit, the number will not be counted against the quota reserved for it.
That is all that we say. That is all that we said.
In that para, itself. Let us illustrate an example. If 19 posts are reserved for SCs, of which the quota for women is 4, 19 SC candidates shall have to be first listed in accordance with the merit.
Correct.
From out of successful eligible candidates. If such a list of 19 candidates contains 4 SC women candidates, then there is no need to disturb the list by including any further SC.
Correct.
On the other hand,
Fair enough.
of the list of 19 SC candidates contains only 2 women, then the next 2 SC women candidates in accordance with merit will have to be included in the list. Corresponding number of candidates from the bottom of such list have to be deleted. So as to ensure that final 19 selected SC candidates contain 4 women. But if the list of SC candidates contains more
Just a
than 4
moment.
women candidates selected, more than selected on its own merit, then all of them will continue in the list.
Fair enough.
My lord
Fair
question.
enough. Absolutely.
Yes.
No,
And
because,
there is no
because
question of
because of what you said in the beginning, that's, we had this problem.
Yes.
We understand, definitely.
I would like to correct myself. I did not put it in the correct way, my lords. In this case, what happened was the matter has reached the Supreme Court, page 50, the consent order of the Supreme Court, my lord. The Supreme Court has considered this and said there is something wrong. Page 40, my lords. Page 40. The judgment dated 29/7/9. The date you are not going to find at page 41 top. 29/7. I beg
Yes.
to read this.
Yes.
Karnataka State Public Service Commission has invited application for selection of masters for headmistress in the high schools of the Department of Public. The petitioner B.L. Narayana was one of the applicants for the post of headmaster. Petitioner had passed the written test and was called for an interview, but he was not selected. In the writ petition, he has challenged the quantum of reservation given to various sections, but these contains no longer relevant for the purpose of transfer. Main grievance with the petition is that 30% total number of posts are reserved for women. According to the petitioner, though the number of posts reserved for women is 351, 451 women candidates were selected for it. Yes, they were in excess of by 67. Numbers not 67 is correct. Which religious that granting reservation.
Yes.
Which religious was granting reservation for women, principal related horizontal reservation. According to the petition, many of the women candidates who have been appointed in excess of the quota reserved for women were not really entitled to get appointed as they had secured less marks in the section. Which religious said there was sufficient number of qualified women candidates to fill up 351 seats reserved for women, but the Public Service Commission appointed more than the required number by appointing less meritorious candidates in fiction of secured.
That is the content.
It's only on the merit.
That is correct. Correct.
Finally, Supreme Court said, my lords, of course, election is already over, they have taken charge. Appoint this person also because he had more marks.
Correct.
They were in excess. They did not, their lordship did not disturb the appointments even though he provided this. What exactly happened was this, my lords. 29/7/9 is this order. Even before this order was passed, we had approached the Supreme Court by page 53 by way of a writ petition. But my lord, what happened was that writ petition on 5/8/2002, and is the date, page 53. 5/8/2002. Learned Council stated the petition want to withdraw the petition, they need to file application by intervention. Yes, my lord, the instruction is, my lord, the Honorable Supreme Court please to observe there cannot be too many writ petitions. File intervention.
Correct. Correct. You filed intervention.
Applications are filed.
You filed the intervention. Then
And
what happened?
intervention applications also came up together for hearing. What exactly happened is some little one, maybe our own negligence. What happened was, my lords, after this honorable Supreme Court granted the relief. Relief portion is, my lord, page 43. In the result, this petition disposed of. Directed to consider the claim of the petitioner highly regarded as claim, Rajesh Mardaria. Decision may be taken with a period of 2 months. Petition is found eligibility may be given appointment. Petitioner would not be getting back wages. Yes, arising out of district petitioner.
Dismissed as withdrawn. Yes,
Didn't you seek review?
there is no maybe there. It was definitely your fault. Dismissed, not just dismissed, as withdrawn.
Under the our misconception, my lords, that relief is granted Rajesh Mardaria, we are also entitled to.
How many of you were there? 23.
That time 23, now we are only 14. As the time passes, number decreases.
6/8/2009.
And my lords, after this, what happened was, state commission said, my lords, yes, they are entitled to. State commission said so, gave a report to the government. But the government said, no, you are not entitled to because your petitions are dismissed. So no relief is granted by the Honorable Supreme Court.
Dismissed as withdrawn.
Withdrawn. And moreover, the state government's contention, which the state has upheld, stating that that was confined only to Rajesh Kumar Daria's case to be applied only to the arrest.
Petitioner.
Only to the petitioner. It is in person
Investment.
and does not apply to others.
How do we get over it?
We were represented by our senior members, industrial members, but there was no proper guidance, no proper instructions given to them.
Now what?
Now, my lords, subsequent events are there, my lord. The government went on giving endorsements to the 9 itself that we are entitled, etc., my lord. But even our public service commission, government said no. Then, my lord, what happened was, as far as the delay is concerned, my application throughout is now dismissed by the ground of delay. One aspect I wish to say, there is no delay. We went to the Supreme Court at the earliest point of time, there is no delay.
There was no delay at that point. 29/7/2009, the intervening application stood dismissed. Thereafter, what do you do?
Thereafter, immediately they approached again, my lord, to the 9 itself, kindly see. Kindly, my lords, we approached the courts immediately, approached the government immediately. We have given the representations immediately, my lords. What the government says is, I'm sorry, A5 is the 9, my lord.
My brother has found out you are seeking recruitment and look at your age.
One thing, sorry.
Petition number 1 is 861.
They're already employed. They're already employed. My lord, to become headmaster, they need more experience. Now they're asked 6 months. All of them teachers.
No, petition number 1 is 61.
Two of them have now, my lord. Two of them have retired. Two of them, I'm sorry. 1 and 2, one has retired, my lord. One only. And all of them are teachers. One has retired. I do concede, my lords, I may not be able to. As far as one is concerned, others, they continue. And our batch only, other teachers, my lord, they have been appointed as headmasters. And immediately we made representations, went on making representations, and one aspect is we got to see in other cases how the tribunal has considered and granted relief. Kindly see page 247, my lords. Other petitioner 2017. 247. The operative portion is 253. Para 8. Considering all aspects, applications are partly allowed, including final selection list related so and so is not implemented. However, response are directed to consider the case of applicants aiming for appointment if they are otherwise eligible in the light of the decision in Rajesh Kumar Daria case. Selections already made shall not be disturbed, etc. One order.
Same recruitment? or subsequent?
How is this?
Headmasters, headmistress?
No, my lord, this is not pertaining to our batch. Not pertaining, next batch. But my
Subsequent.
lord, subsequent batch is considered, and not only
Different
that,
six
this,
batch.
the coordinate bench of this only quote, my lord, next order, page 254.
Same batch, same batch.
For this batch only. The
Additional
next order is
Additional
for this batch only. That's a judgment dated 15th January 2021. There. Same.
Seniority, seniority.
They were.
It also refers to B.L. Narayana,
Oh,
if
BL Narayana
Rajesh Kumar
was-
Daria.
Therefore, my lord, they were appointed, as far as seniority is concerned, my lords. Relief was granted, para 14 and 15. The mistakes has arisen because of our mistakes. I will consider that we could not probably put the case proper. We are under the wrong impression, that's all. That it would be applicable to everybody. Rajesh Kumar Daria would be applicable to everybody, and it was. But subsequent also the how the government has done, and as far as the election board is concerned, my lord, page 20. Yes. 207, my lord.
Translation copy.
They have produced a translation copy of this, where the comment themselves said on 1207 and 12, that the case has to be considered. That page 208, my lord, they have quoted edition of the coordinate bench of this on court. Middle portion, it is not necessary for every person to approach this court for relief, similar to the one already granted by this court. The edition has been rendered by this court. Like cases, before that. That should be a guiding principle in the mind. Not proper, every person. It is clearly educated authority in the benefit. And also, my lord, there's other decision at the bottom. Those who could not come to the court need not be, they compare and to disadvantage those who are here. If they are otherwise in the situation, they are entitled to similar situated and they are entitled to similar treatment, if not by anyone else at the hands of this court. Burdened by all the relevant considerations and. My lord, regarding us, my lord, type the copy we have produced, my lord, the gist of this order is that the government has to extend the benefit to everybody. Type copy is also put on, that is
What is that? Is that a government order or some
government order,
modification?
The report can be perused at the type copy. July 2024, type copy of this translation copy is produced. In respect of the very same petitioner. Government has written this letter to the KPSC, my lord. Consider it and they are entitled. After considering everything. The fourth page, my lord.
That will be, that will have to be redone.
Supreme Court specifically said that that was not the- It's done. No.
Only writer in this communication by the government is, my lords, that we should not claim any seniority. And this was approved by the chief secretary and the chief minister. Last end of page, my lord. Consider for appointment, you give the appointment.
Again, is not a communication of a executive decision of the government under Article 162. Yours faithfully signed, Under Secretary to Government, Education Department, Higher Education.
Last.
Not a government order. It is only a letter from the Secretary to Government to the Secretary Public Service Commission.
And what the KPSC said, my lord, next order, produce next copy, next order, KPSC said, we will implement it subject to what the honorable court says. Nobody stopped them from implementing, my lord, sir. Since this was an order, my lord, with the, issued with the approval of the secretary, my lord,
It's not an order at all.
that I approved, by is mentioned, my lord, I do not, I only beg to submit this is the stand of the government, my lord. What stopped from the repeal only because the tribunal said, no, 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 you are not entitled to. My lord, whatever that may be, Supreme Court said.
No, we can direct a reconsideration at best. We can direct a reconsideration by the government, but it has to come from them. We cannot say that after having, in a case where a person is not able to approach the courts
Yes.
because of several reasons, that is another matter. Here is a case where you were there before the court.
Not be more disadvantage than a person we approach. We approach, I approach it. That is
Therefore-
not a- I approach, my lord. I never denied, your lordship may kindly see this, finally what should have been seen by the
No,
tribunal.
at
was-
that point in time, you should have also pointed out, we are similarly situated persons. We had filed an SLP that was rejected on the ground that we will be heard at this stage. Therefore, the benefit should be extended to us also. You are only 23. It probably we don't know.
How we understood was, my lord, that the Supreme Court has extended benefits, only we are also entitled to us, nothing remains. Rajesh Mardaria said the same thing, and only question was whether our marks are more or not.
Headmasters can be
Just-
heard to say that you did not understand. It were
Yeah,
some
The-
grade
no, the-
4 post we
The stalwarts also, my lords, were before the honorable Supreme Court judge, who was also the honorable, the great regard we have, my lord, Ramanathan was also governor, who was appealing for us, my lord. Their opinion was this. My lord, please, we cannot be penalized because our advocates, we have engaged the best of services, their opinion was this. And they would not have sought an order against our disadvantage. It's what they thought because of this. I do not say anything. more.
everything is clear as daylight.
We are here before the honorable Supreme Court for this purpose, my lords, that we are also entitled to relief.
It
Denying
can be
us-
considered by the government. If the government sees it fit to grant it, well and good. No, there is no question of any ousting. There is no question of any ousting because all the directions in the interregnum seem to say that if they can be accommodated, probably accommodation also will not be an issue because many of them have retired from service. It will only be notional. But the question is, can this court or the tribunal take such a decision? We cannot. Because that will have to come from them. As a matter of fact, the Supreme Court, with regard to this selection, only gave the benefit to Narayana. Therefore, if the others who are similarly situated are to be granted the benefit, then it should flow from the government at this stage when the interpleading applications stood dismissed as withdrawn on 29/7/2009. We cannot now say that you have to give it. If they give it, we will not stand in the way.
Really take judicial notice. As far as
Probably the government says at least in September.
All 939 posts were filled in 96. Notification was for 939 posts. All those posts have been filled.
Additional list also operating. We have to do.
Pura agilla, and the second list, there was an additional list.
So if all 939 posts have been filled, then where do you stand?
They are not filled because additional lists were there. 351 is what stated is my lords and the order.
Somebody is to be dislodged, that person is not made a party in this petition.
No, there is no question of dislodging. If there has to be a dislodging, it cannot be. Because at this distance, 1996 elections,
My lord,
to dislodge
my lord,
dislodge
we are not
somebody
going
who's
to-
sitting there is,
If there is such an occasion. My
you
lord,
cannot be, it cannot be even considered.
By our understanding, it was not proper the understanding, that's all. We need not be continuously penalized now, at least now, wrong has to be set right, my lord, so the grave injustice has occasion because of this. We thought the Honorable Supreme Court is giving the relief to everybody, and the government also said so, the communication speaks of that. At one point, the government wing took a view that.
Just a plain reading of the order. You're all headmasters or teachers aspiring to be headmasters. Just a reading of that order would make it crystal clear that there is no benefit given to anybody but Narayana. And therefore to say that you did not understand it, well.
What it led to our- what it was, my lord. I will put the second link of my submission. my lord. Assuming that the Supreme Court did not do it, doesn't close the doors. We have approached immediately the KT. Please grant the relief. Now the KT cannot deny the relief only on the ground that Supreme Court has not granted. Supreme Court did not grant, we will presume that the Honorable admit Supreme Court has not specifically granted the relief. Based on that order, we approach the KT. Now the KT cannot say Supreme Court has not granted, therefore we are not.
Why did you go before the Supreme Court in the first place? You filed an SLP. Why did you go before the Supreme Court in the first place?
They filed a petition, then the.
Exactly. Therefore, after the writ petition was filed and after you went up to the Supreme Court, filed an SLP, got it dismissed as withdrawn, filed an interpleader application before the Supreme Court, got it withdrawn. What can the tribunal do? The tribunal's hands are tied. Because this very same matter you have agitated up to the Supreme Court. And when you could have agitated it, we never know. Suppose maybe it had been agitated and the Supreme Court was not inclined to grant the relief, which is why you withdrew your application. We are not aware. Even if it is not so, having gone up to that level and having withdrawn your pleadings, now to come back to the tribunal and say that the tribunal should consider, I don't think there is every authority till there.
I really have to submit, no words can express our difficulties and we have answered. The problem is only this, my lord, similarly placed persons, we are also in the same boat. And for us, it's not granted.
Whether the government can consider the matter again,
Again, the board can accommodate only 939.
that is the problem. No, there is no question of dislodging. Without dislodging, whether any benefit can be extended to them, appear to be legally, genuinely entitled. But the difficulty is that they did challenge it and withdrew the case and withdrew everything that was pending. And the tribunal may not be able to grant any relief. Even we cannot grant the relief. It can only be the government in exercise of its discretion that can grant the relief. For this court to say that the relief that you sought and withdrew from the Supreme Court, we are granting. We travesty, we can't do that. Yes.
For vacancies are concerned, my lord, I'm very sure headmaster's post.
Technically speaking, it is claim given up.
Whether if they are willing to reconsider the matter, we will not stand in the way.
Please.
Learned government advocate seeks time to get instructions in the matter. List after 3 weeks. There is any opening?
Openings in the government is always there.
Opening in the sense that government, opening for the government to reconsider without ousting. Please. It is the delay is what is creating the problem. It appears that persons who were similarly situated were given the benefits also. It is not as if they didn't go. They made an attempt. Well, what happened to the attempt? We don't know.
Those observations, it depends on faith now.
Let him place. Otherwise there'll be no point in this entire exercise. If they are going to stick to their earlier stand, then there is no point requiring them to consider also, except to give these persons a false hope. That we don't want to do. If there is any chance, then we'll.
Please, most.
After 96, was there any such similar notification inviting the application?
2006, that
Oh,
was 2006.
one more is there where the same principle was applied, Rajesh Kumar was applied.
No, there you didn't.
Now they have given up the question of reservation, thankfully. After which
They are following
reservation has
Rajesh
been.
Kumar, I feel, now they are following Rajesh. Where it is not followed, they said this one could also follow Rajesh. Our problem is we approach the court. Had we not approached,
This one should not apply.
and informed in one more case, the supernumerary posts were created to answer.
All that is
No, no,
to
in
them
one
to
case
do.
it was done, my lords. I'm not, I don't know. Injustice has been occasioned, I'm putting it before the. Is in fact a case where, my lords, government may consider it favorably. Most favorable.
Yes. 26.
Last 2 years,
Transfer.
yes. Vacancies are there.
31st.
Serial number 33, so transfer matter, my lord, interim order is operating against me. May be repeated on Monday. In the orders list, my lord, because this more than 7 times it has been listed but not reached. Monday, after orders list.
Monday, no service matters. Yes.
Number 28 minutes. I request from 6 status.
Any dates, please mention to the board.
ಆಗ್ಲಿ ಬೆಳಗ್ಗೆನೆ ಆಗೋದು 6 26 31 sir.
ಮಂಡೆಗೆ ರಿಪೀಟ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದೆ.
88 32 Tuesday. 33 Tuesday. 13 30ಕ್ಕೆ ಬರೋಣ. ಆಯ್ತಪ್ಪ ಅಪ್ಪ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಇದೆ ಇದೊಂದು ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ MH ಗೊತ್ತಿಲ್ಲ ಇವಾಗ ಎದ್ದೋದ್ರಲ್ಲ MH ಗೆ ಅರ್ಜೆಂಟ್ ಇದೆ ಮತ್ತೆ ಅವ್ರ ಏನಾರು